Yes. For Friday. His petition against Guardian.
Day.
Friday.
Thursday. Thursday.
But I was absent yesterday because of my father's petition. There was an order passed by your worship in a matter by the MD Associates Director to be personal. 6th of May. He's the election observer for the Panchayat election. He's the election observer for the Panchayat election. And on 6th and 7th.
When is the election?
What?
When is the election?
Election is on 7th. Election is on 7th.
I have not asked him to be present here.
My lord, what I sincerely pray. He'll come, you personally come, no problem.
Not, I don't want him personally. I want him to be out there.
Why not? What my sincere prayer is, it can be taken up after 17th of May any day, because see, on 6th of May, all the election materials will be distributed and it will be difficult for him to inspire.
We'll see on 6th of May. We make the prayer on 6th of May.
Look, I done higher today for just alteration of that date, nothing more.
We'll see on, we have fixed it on 6th of May. We'll consider it on that, not today.
But I have filed, it's for the alteration of that date on 6th of May.
Mr. Counsel, I will take it up on 6th. If this court finds it that it is a justifiable cause, I will permit. I will dispense with his appearance on that date and fix another date. But
And
the
my lord, this
question
I-
is, as of now, you are not going to mention this thing, the change today.
Then I have filed today. May it be listed along with that matter.
Why should I give it? Are you not aware? How many years of practice do you have? How can you mention the matter is already fixed on 6th? Do you want the IA prior to that?
No.
Then
This IA is fixed.
why should I do it? Whether you file, when you file the IA will come. You have to take it up with the registry. Whether the IA, if it doesn't come on that day, you make a mention. Don't you make this type of submissions before. Next. I can't call for. IA number. Mr. SP who submits that an interlocutory application has been filed being IA 25. The same interlocutory application will listed on with the instant proceedings. 5th of May.
The Lordship, I beg to mention item number 1, Your Lordship. The Lordship, the learned counsel R. Sharma, who was supposed to appear in the case, has lost his father on last Sunday. Your Lordship.
Huh?
His father lost, he lost his father last Sunday. Your Lordship. Learned counsel R. Sharma. Can you, Madam, please, after 20 days, 21st,
Counsel appearing on behalf of the petitioner seeks for an accommodation on account of the bereavement of Mr. R. Sharma. The learned counsel appearing on behalf of the Mr. R. Sharma, who is leading the instant proceedings. The learned counsel who is leading the instant proceedings. Taking into account the above, is the matter again on 21st of May 2000. When is the next date fixed in the execution? 1st of May, they are. Why we file delay? Okay. For setting aside. Your order 9 rule 13 application has been dismissed. Against that you have approached. There's a delay. Then what can I do? Can I condone the delay on the first day? Then so have you filed an application before the lower court? No. Have you filed an application before the lower court under order 21 rule 29 or order 21 rule 26 before the executive court? You have to file that.
That's why we mentioned the item number 12 lots. Item number 12 lots. In item number 12 lots, in page number 5, typographical mistake is here regarding date and one word lots.
Huh?
Like correct. Typographical mistake lots in my petition regarding date.
Don't worry. I think it's good. Don't worry. I don't look into those dates. Next.
The transfer petition can it become 1 day for order?
Why?
Since the RAM petition, why case is pending the 23, by the separation. Pending. 2 cases, but is separating by case.
Fifth of May. 5th of May.
But party is concerned from other side. First work from the.
Huh?
First work from the.
Which one?
Item 13.
13.
From other.
Why?
So.
The motion matter, why?
It's something.
Tell him, we have it after 8 weeks. The request of the learned counsel appearing on behalf of the petitioner. Item number 13,
32.
32,
What is?
32. 52. Why? Why should I fix it? It's a 2022 CRPIO.
Why?
Absolutely no.
From other side.
Huh?
I've taken consent from other side.
I'm not bothered with that consent. Everybody knows this consent doesn't work here in this. I'm not bothered. Ask him to present those.
For motion item 2.
What is this?
Coming, one batch of petitions have been dismissed by my lord earlier, only on the plea of limitation matter in the learned court.
Huh?
One batch of petitions have been dismissed by my lord on the plea of limitation. Only one plea was raised before my lord that regarding limitation before the learned court below in the court of additional district. So my lord, if my lord kindly comes to page 69. 869.
Yes,
Relevant page is at page 72.
72.
And the issues, madam, at 4, madam. Although record does not reveal framing of any issue during the course of hearing argument, with the assistance of the learned counsel for the parties, following issues points have been framed so that the contentious points can be decided by these court petitions. At the time of hearing, my lord, the issues have been framed, and my lord, the evidence was led beforehand, my lord. And the issues were framed only at the time of hearing, my lord. So, my lord, after the framing of issues, my lord, we should have a chance to read evidence.
You have not laid evidence.
No, my lord. No, my lord.
Why?
My lord, because my issues were not framed here.
These are not issues. There is no question of issues, framing of issues also in these type of proceedings. He has framed it for his convenience. These are more Particularly, we may put it as points for determination.
My lord, but after that, my lord, we
No, absolutely no. In a reference proceeding, there is no question of any issue business.
my lord, this is the original proceedings, my lord, before the decision under 60.
Absolutely no, Mr. Sharma, you must be knowing it, that the
My lord.
question of in a reference proceeding, the question of issues is completely foreign. So this will be considered as a point for determination.
My lord, there's not a, my lord, another issue is the application of the multiplier. In some cases, the fruit bearing trees, the yielding years, the number of prospective years have been calculated to be 13, 14, 15. But it should have been a flat rate of eight yielding years for the fruit bearing. In agricultural land, it is up to 12 or 13 years calculation. But here, my lord, in philosophy, all the matter, the calculations, my lord, of the additional district judge, it has gone beyond the number of yielding years. My
What?
lord, I know at this stage, my lord, my humbly pray. Then my lord may just issue notice, my lord.
Absolutely no. This type of matter should be immediately finished.
No, my lord, I don't see much.
Gomari trees, they have only taken 7.
My lord, I don't
7
see
is
much-
too less.
I
It
don't
should
see
have
much.
been much more.
My lord, I don't see much time. My lord, please just give me 2 weeks.
Mango trees, only 7 years. My goodness, mango trees are much more. Then 8 years for betel nut. Nothing happens at the
My
8
lord,
years.
my lord, there are some
13 years for coconut trees. Well
there-
done.
but there are issues.
Then nothing is there.
But there are issues, my lord, regarding
Have you paid the money?
my lord.
Have you paid the money?
I paid. I know, my lord. Initial payment we have all made.
No, these.
This is not yet, my lord. We are subject to your lordship orders after your lordship here. Eventually, we are.
We dismiss it right away.
My
We are in 227.
my lord, may kindly issue notice. My
No. We'll dismiss it right away. This type of matters we should not. This
No,
is
my-
an order of 12th of April 2023. You are challenging now.
Transfer matters.
So what?
Each and every case. my lord.
Absolutely no. Why you are challenging now?
Because we had
We
initial.
are in 2025. 2 years have passed by.
My
You know,
lord,
what is the great
in
reason?
the batch
Fine.
of CRPs which we have filed before this honorable court, my lord, it was held up in the filing section because the registry had the notion that we have to file it under writ petition. And so it was for 4-5 months, it was just held up, my lord, in the registry, my lord. Prior matters also. So, my lord,
I am not
seek
concerned
to-
with
I
that.
seek to indulgence, my lord. Only 2 weeks, my lord, of 1
You
week.
filed it on 5/4/2025.
My lord.
Then nothing remains. After 2 years, what is the good reason for that? I'm not going to exercise 226, 227 here.
My lord, may kindly,
Absolutely no. I'm not. Where is the explanation for delay?
my lord, we don't seek to delay the justice, my lord. We delay the wheels of justice.
No.
Only issue, my lord, can you give us a hearing? My lord may fix it in.
I'm
3 days.
hearing you now.
My lord may hear all the parties. My lord may just fix it for 10 days, my lord.
I'm here holding it now.
That's all I seek.
Let us hear it. I have no time. I have lots of time. Lot of matters have been adjourned. Okay.
My lord,
I should be entertain this type of petition filed after 2 years. First,
my lord,
although there is no delay or lapses in the part of 227, but that doesn't mean that in a case pertaining to this type, you are going to delay after 2 years and file.
my lord, we have been very diligent. We have been, for all the cases, we have to take up certified copies, my lord.
So what?
Send it from Hailakandi to send it to Imphal, then to Shillong, in the region.
Does it take 2 years for that?
My lord, we have
You
filed it.
applied for the certified copy only on 12/2/2024. You got it on 23/23/2024.
very correct.
Then,
My lord, we have filed a
Then-
batch of petitions last year itself, but it was held up in a registry. So the rest of the matter.
these are not held up in the registry. This
No,
was
no,
filed on
it-
5/4.
These we have filed later on after.
So we
those-
dismiss these type of petitions.
My lord is very correct, but my lord, can you give us 10 days or 14 days time, my lord?
Absolutely no. These are matters to be finished up immediately. People have been
Madam,
deprived of this amount.
My
You
lord,
have
this
been
matter is
done
not
this.
a reference proceeding.
How much amount has been given?
Because
Not
there's
given
a huge
anything.
lot of, there's a huge lot of claimants, we are bound by the lordship order.
Yes, you are
We-
bound not,
we are bound by
you are
lordship
not
order.
bound by my order there. You are bound by these OFF orders.
My lord, but
You are you are liable to pay.
my lord,
How much the court has given?
in this particular case, my lord, the total is 7,21,000 at a rate of interest of 6% per annum.
Very well.
And my lord, in the rest of the also, in some there are 15, and my lord, in some cases, my lord may kindly just look at a multiplier adopted, and as well as my lord, adducing of evidence.
What is there adducing? You were given the opportunity, you should have adduced the
No,
evidence.
my lord, the basis of what, my lord, the issues have not been framed. We are just being,
No, is it required for framing of issues?
my lord, then
Is it ever heard of in a reference proceeding an issue is framed? Is it ever heard of? What is required to be decided is only as to whether the amount is likely liable to be paid or not.
My lord, this is 16.3, my lord, under 16.3, my lord, we go to the, when we are.
Have you filed your written objection or not before the court?
My lord,
Then thereafter, did you play that you want to adduce evidence?
my lord, because my lord, they have already taken evidence and the role of the state also. Can you see the role of the state? They are the ones who have made the charge. They are the ones, the officers have come. And during the evidence, exhibit 3 at page 76, my lord, in view of the expert opinion revealed in exhibit 3, as serial number 22, it is clear that the said petitioner could not have yielded food at least for a period of another 8 years. Now, my lord, who is the expert here? He's an ED of the DC office, my lord. He's not an expert.
You know, did you raise that issue before that court? We are in 227, Mr. Sharma. Then, did you raise that issue before that court? No. Don't blame others.
No, we're not taking on one.
You do one thing.
It's not blame.
You do one thing. If you don't want to pay, don't pay.
No, we'll pay.
No, you remove those things where you have taken over.
We are bound.
No, you are only taking the right of way.
We're only taking the right of.
Right of way. Don't take the right of way. You give up your right. Even undertaking before this court that you are going to give up your right of way, nothing is there.
But the transmission lines have been already been established.
And return of this
Only the
property.
issue of the
Nothing doing.
multiplier.
Absolutely nothing doing. These are matters of 2017 and till now you have not paid it. My goodness. No, dismiss.
Madam will deposit the money in the court. Madam in the learning court below. Madam will deposit the money.
Deposit the entire amount along with interest
My lord.
within 6 weeks.
My lord.
You deposit entire and I give the liberty to withdraw the entire.
No, madam, we'll pay the money.
Absolutely. This is
pay
to
the
be paid and withdrawn. No deposit in the court. Nothing doing. You deposit before the treasury out here, the registry out here, within 3 weeks, you deposit the entire amount, and then we do. And then on that next date, we dismiss it. Deposit with interest within 3 weeks, and then effect service by way of dusting, and then we'll pass.
From 2 to 7 are the similar manner. 2 to 7 similar also. Arising out of the same judgment.
I thought about the side you go. Because so we don't require to stay.
My lord.
There's no requirement of stay.
Already paying that.
No, when you are depositing it before the.
Actually, madam.
So there's no requirement of stay. You're depositing it. But on the next date, I will allow these people to take it out. This is the only way of faster execution, nothing else. Don't worry, this I'm going to dismiss it on the next day. Only thing is that I'm getting this thing first initially done so that you make the payment and then when the claimants come, I'll ask them to take it.
We'll deposit the money within 3 weeks, madam. We'll deposit the money within 3 weeks, madam.
Along with interest. Heard Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner. Learned senior counsel appearing on behalf of the petitioner, assisted by Swens. I've also heard Mr. T.R. Bhutel, who appears on behalf of the respondent number one and accepts notice. Extra copy of the petition of the instant application is served upon him during the course of the day. As regards the respondent number two, steps be taken for the issue notice, making it returnable on May 2025. Subsequent, Mr. So-and-so appears on behalf of the respondent number one and accepts notice. As regards the respondent number two, steps be taken by way of registered as well as usual. In addition to that, the petitioner is directed to take steps upon the respondent number two by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. Next. The petitioner hearing have essayed an order dated 12/4/2023, casting Miss bracket PG case number 16/2017, whereby the learned court of the additional district judge Hailakandi by the order dated by the order held that the petitioner hearing, the respondent number two hearing is entitled to an amount of rupees 7,61,210, along with interest at the rate of 6% per annum from the date of filing of the petition. It was also observed that the amount already paid be deducted from the total amount payable to him. This order was passed on 12th of April 2023. Almost after 2 years, the instant application has been filed by invoking the supervisory jurisdiction of the court under Article 227 of the Constitution. It is well settled that the laws of limitation do not apply. Let us dismiss it. I've written so much. Let us dismiss it. No, Mr. Sharma, this is
depositing
not.
the amount.
No.
within 3 weeks.
No,
We're depositing the amount within 3 weeks.
absolutely, let me dismiss it. This type of matters should not be allowed.
My lord,
What do you say, Mr. Goy? We should dismiss it right away. Earlier also, I dismissed it. This type of matters should.
only on the point of liquidation in that. Kindly,
Not on the others also, I don't find any ground.
we are depositing within 3 weeks, my lord. Just give us one hearing. On 16th,
I'm hearing you. I'm giving you a proper hearing. What hearing? What matter is there?
my lord,
No, except that I'm going to deposit. There is no other ground. You don't have any ground. No, I'm hearing you.
my lord, on the 16th, my lord.
No.
We'll
This
come
type
and
of
satisfy your
matters
lord
should
if
be
my
finished.
lord, my lord.
What do you
Ultimately, my
say,
lord,
Ms.
we are-
Gorman? Dismiss, na? I can do one thing. Good. The matter having been heard This court have duly heard Mr. R. Sharma, the learned senior counsel, assisted by Mr. D. Deka Pusto. The matter have been heard at length. This court had made a pointed query upon the learned counsel appearing on behalf of the petitioner as to what reasons are there that the instant application, the supervisory jurisdiction of this court have been invoked almost after a period of 2 years. Mr. R. Sharma, the learned senior counsel, submits that he would obtain instructions to list the matter on 2nd of May for further hearing. I'm giving you the second hearing. On second,
Item 8.
Yes, none appears for the petitioner.
Item 8.
None appears on behalf of the petitioner on call. It is seen that this is the second occasion on which the petitioner is not represented. Considering the above, the instant petition, and considering the above, it appears that the petitioner is not interested in the instant proceedings, for which the instant proceedings stands dismissed for non-prosecution.
9.
Yes, what is this?
Matrimonial dispute, my lord, herein the petitioner before lordship preferred a petition in the family court within 1 year of marriage for nullity of the marriage. Now, after appearance of the respondent, thereafter they stopped appearing. So ex parte order was passed by the trial court below. Against that particular ex parte stay order, they approached this Honorable High Court. This Honorable High Court, by its order dated 1/6/2022, my lord, was pleased to set aside the ex parte judgment, and wherein at page 31, my lord, last paragraph, my lord, last line, we also previously find, force it a submission so and so that the learned court below has recorded finding regarding the mental health condition of the appellant without being supported by evidence of any doctor. Now, after being remanded back, the petitioner's evidence is over, and we have given list of 3 doctors. Now, on that particular day, my lord, we have taken steps, but all of a sudden, my lord, will kindly see the impugn order itself, my lord.
Wait.
Yeah. There you go. My lord, will kindly see 16/8 order at page 39.
Wait.
39, but
Today is the date fixed for filing of evidence of PW.
yes.
But the petitioner has filed a petition seeking time to file further evidence of 3 witnesses as given in support of his case, according to fair is allowed. Also, peruse the petition filed with a response stating that she does not have any objection to granting
Yes.
a decree of divorce resolving the marriage in between the human, subject to payment of the fixed for necessary orders. Then,
Then my lord will kindly come to page 40, my lord. Parties are present. PW1 is cross-examining. Petitioner asks to submit a report before this court as to why the examination of PW2, 3, 4 is necessary in this case. Petitioner paid sum of rupees 9,000.
what happened to that compromise?
Yes. For report. We have asked for 3 witnesses. Why court is, after allowing it, asking us that why we need the evidence of PW doctors. Accordingly, petitioner paid the sum of rupees with regard to maintenance. Now, 25 to order, my lord. Parties are present here. The parties, after hearing the parties, petitioner is allowed to call Dr. A. Kayal on 18/3. One doctor was allowed. And on the next day, we have taken steps. Now, step has been taken, kept on record, my lord, and this order has been passed. Petitioner failed to take any step to issue summons to Dr. Kyle. Accordingly, it is considered that the petitioner declined to proceed with Dr. Kyle. Repose sums for today, fixed for evidence of deed.
How do you know you have taken steps?
We have taken steps, my lord. We have made a categorical statement on
No, no,
oath
no.
before
It is not categorical statement on oath that would not help you. If you have taken steps, there will be proof of taking steps.
Absolutely, my
Where is
lord.
the proof of taking steps?
My lord, it's been already in, always in the family court, my lord. It's, our duty is to submit to the authorities concerned, my lord. And the authority concerned was the Stano, and who took the record inside. And it has been informed to us that the steps has been taken, kept on record. We do not know what has
Then
happened,
file a review.
my lord.
File a review. Then if you have taken steps, this is the, how can this court look into it unless for calling for
My
the
lord, with
record?
that direction, my lord, we will file a review.
No, I'm not going to give a direction. You should file a review. Petitioner failed to take steps. This is a question of fact.
My lord, we kindly see, we have also challenged the order dated 25/2 also.
Why?
After hearing the parties, KKL, so only one out of 3 doctors, my lord.
Then you have, but then also you have taken steps only against one.
What, my lord?
Why haven't you challenged this order of 25 to 2025
We have
earlier?
challenged-
Why
Yes.
earlier?
not
Why
after,
not
my lord.
earlier?
Together we have challenged
Then-
this.
And then you say that you have taken steps against Kyle. Wouldn't it amounts to that you have already taken, submitted yourself to the order
We have-
passed
We have
on so and
received-
so?
We have accepted that.
Then, file review. These type of matters cannot happen.
Well,
If
in
it
that
is
case,
something
my
is
lord,
wrong out there, very
My
well.
lord, will kindly see, my lord. Ultimately, it is the High Court who has said the doctor is necessary. We have given the list of doctors. Only we can do is to give the list, and whenever it was allowed, 3 doctors. And thereafter reviewing its own order. And apart from that, our hands are tied so far, steps are taken, my lord. It is the duty of the courts, my lord. We have to submit to the court, my lord. That's all we can do, nothing more than that, my lord. Even petitions are marked.
Mr. Bhuya, when you take steps out there, it will be put in the record that there have been steps have been taken.
My lord.
Then-
It has been kept on record,
If it
but
is kept on
and the
record, then,
court comes to a finding,
then
my lord.
why don't you file a review? What happened on 26/3
My lord,
for DWs?
well, we have, my lord, communicated to the court that we have preferred a civil revision petition against this order. And that's why the court didn't take up this matter. Right?
But isn't it wrong? You just informed on 21, you filed on 21/3. And what is the next date filed? Next date fixed.
Next it. Keep in abeyance because we have informed the court that we have filed a CRP.
There's no date fixed.
Keep in abeyance, no date.
Cannot be. How can the court do that?
And we have been informed that after the High Court's order, same should be communicated to the lower court. That's been the.
Be like this.
Paragraph 8, my lord, we have made a categorical statement.
Your categorical statement, what am I going to do with that?
I understand, my lord, but
Where's your petition? Seeking PW 2, 3, and 4?
not been annexed in this petition.
Why? Then how can I adjudicate 25/2?
Absolutely. Ought to have been.
Tell me. I don't know.
Copy of the petition has been there with me. That is 16/8.
Because when you are exercising the rights, The CPC follows there.
Yes.
Now, once the CPC follows, you are to give your list of witness at the time prior to framing of, immediately within 15 days from the date of framing of the issues.
Yes.
You have not given, most probably.
But after setting aside by the High Court, my lord, immediately we have given the list of the three.
In that list of witness, you did not give PW 234.
That is the PW23 doctor.
No, it cannot be because the date was fixed for filing of PWs. Then only you filed an application saying that you want PW 234, which means you have not done in terms.
Yeah.
So therefore, you have to
It
give
is-
good reasons in terms with order 16 rule 1A as to why you did not do so and now why you want them.
Yes, my lord.
Where is that
Petition was
reason?
preferred, my lord. The prayer was this, my lord. Would be pleased to allow the petitioner call Ashok Kumar Kai.
Why?
So and so, so and so, so and so.
Why?
After being remanded back because the doctor has to be examined in this case. Because
Understood. Doctor has to be there, but have you mentioned in your petition?
yes, the doctor's name to call for.
Have you mentioned why these doctors' evidence is required?
Yes, my lord. So and so, so and so, so and so, so and so, so and so.
I'm done.
Patient department, so and so, so and so. In this case, my lord.
Heard Mr. A.K. Bhuya, the learned counsel appearing on behalf of the petitioner. First, the petitioner have assailed before this court the order dated 18/3/2025 passed in FC civil case number 272/2018, whereby the learned court of the principal judge, family court, Kamrup Metro, family court number 1, Kamrup Metro at Guwahati, have observed that the petitioner had declined to proceed with calling Dr. A. Kyle for examination and close the evidence of the petitioner and fix 26/3/2025 for evidence and cross-examination of DWs. The learned counsel appearing on behalf of the petitioner submits that due steps have been taken, but however, this aspect, very aspect of the matter was not taken into consideration by the learned court below. This court is of the opinion that if steps have been taken, the same would definitely appear with the records. Under such circumstances, this court, while not entertaining the instant proceedings, permits the petitioner hearing to file an application seeking review of the order dated 18/3/2025 before the learned court of the principal judge, family court number 1, Kamrup Metro at Guwahati. The learned court shall duly consider the review application in accordance with law.
Deeply obliged. Deeply obliged.
Accordingly, the petition is closed.
Obliged.
Captain.
Yes,
Yep.
what is this? What you are challenging?
I'm challenging the ex parte order, my lord. Since my lord, date was fixed on 20.
Where is your order?
Order is at page, my lord, 114. Prior to this, my lord, your lordship may kindly produce the earlier order, my lord, at 25/11/24. That is at page 112.
What order you are challenging?
My lord, because my lord, on 25/11, my lord, that is at 112.
No, which order are you challenging, Mr. Counsel?
My lord, I am challenging the order dated 30/11/20.
Page
Page 114, my lord.
114 I've read. What is wrong with that order?
My lord, since my lord, we have not been heard, my lord, on the
No,
earlier date
it is being fixed out there for objection, hearing and report.
for non-scheduled date, my lord. That is, that your lordship may 112, your lordship may kindly bear this.
Huh?
After receipt of the summons, my lord, we have appeared before the honorable court, my lord, at 112, my lord. Matter was fixed on 16/12/2024.
Petition filed so and so. OP has filed petition and the state has sought an adjournment on the ground that we are for objection in objection hearing. Then,
Then my lord, order is passed on 30/11/24, my lord.
what is that?
That order, my lord, impugn order.
Somebody has put up a petition. Somebody has filed a petition on an off date. And then the court says that we are going to hear you before passing an order. That's all.
But that order, my lord, itself violates, my lord, since my lord, 2016, they have filed another violation petition, my lord, which was also rejected. That is that I have.
Understood. Then why you are not going before that court? What is that order? Tell me. Who are you?
I am the defendant, my lord.
You are the defendant.
My lord.
So you appeared on at part 112.
My lord.
You appeared. Petitioner filed Hazira. OP 1 and 2 has filed Hazira.
My lord.
Okay.
My lord.
OP number 1 filed petition. OP means you. And white petition has sought for an adjournment on the ground as mentioned here. OP 2 and 3 white petition has sought for an adjournment and fixed 16/12/2024 for objection
But-
and hearing.
Without opportunity of objection, my lord, filing of objection, the court passed the order on 30/11/24, my lord.
No, wait. For objection and hearing. Now let us see what is 3011. CR
3011
put up on today on the strength of a petition filed by the plaintiff petitioner under 151. So and so it appears miscase notice have been served upon so and so which was allowed by the AR. The matter has been fixed on objection on 16/12.
My lord.
It has been found that Ms. Valens in connection with the same matter of the petition is also pending at the stage of evidence and the next date in that case is also fixed on 16/12.
Fine.
In the facts and circumstances as in the instant petition, keeping in view Ms. J case number 186 as well as Ms. Violation, I am of the consider an opportunity has been heard should be given to the OPs, that is you.
My lord.
As the matter in that said connected case has already been fixed for hearing on 16/12. Accordingly, let the matter be fixed for hearing together on 16/12.
Right.
However, in order to avoid inordinate delay and taking proactive action from the court, so I deem it fair to call the police report from so and so. Alleged illegal construction. Accordingly, call for the report, furnished report, the OC shall prepare a report. AI is also directed to necessary action for required so and so. Send a copy to this. Then what happened?
My lord, although my lord, we have not been heard, my lord, on that day, my lord. On 30/11, when the order is impugn order is passed, my lord. And 25/11/24, my lord, we have appeared before the court, my lord. Court allowed.
Now, what happened on 16/12?
16/12, my lord, necessary order, my lord.
Did you file your objection?
No, my lord, we have for your lordship.
You approached this court when? 21/4/2025. What happened on 16/12/2024?
We have not filed any objection.
Then if you are not filing, why should we at all take into consideration these type of petitions?
But in
Yeah,
that case, my lord, I would like.
No. Ilm or TSEC, which one? Should I dismiss or withdraw?
Or withdraw to file the objection.
No, absolutely no. I don't know what has happened up
But-
on 16th.
One
No,
order, my lord, your lordship.
Mr. Counsel, which one do you want? Dismiss or withdraw? You go do whatever you feel like there. But this is not the way. First of all, you have made an incorrect statement before this court that you have approached this court, therefore you have not filed an objection. You are supposed to file the objection on 16/12/2024. But you approached this court only on 21/4/2025.
My lord, only one order, your lordship, made 23/11/16, my lord, wherein that violation.
I am not concerned with that. What that order is, that has nothing out there. We should dismiss with the cost of 1 crore, 1 lakh. Chalo,
In
let
that
me
case, my lord,
dismiss
I
with the
will
cost of
withdraw.
1 lakh. Heard,
With
miss?
liberty, my lord.
No liberty. What liberty? Absolute no liberty business. You do whatever you feel like. There must be something hidden out which you have not disclosed. Why haven't you disclosed after 16/12/2024? What happened?
I will.
You filed it on 21/4/2025. In the meantime, most probably 4-5 dates have gone. Then why haven't you mentioned anything out here? This is a case of suppression of material facts for which I impose a cost of rupees 1 lakh upon
My lord,
you.
I will furnish the.
1 lakh upon you and 1 lakh upon the petitioner, and both shall be recovered as the areas of land revenue by the deputy
My lord, I
commissioner.
have not availed, my lord.
Absolutely you, because you are the person concerned who have not stated anything after 1612. Why haven't you mentioned anything what has happened after 1612?
I will furnish the copy, my lord. Court order, my lord, I will furnish.
Court order is of
Day after tomorrow.
1612.
Day after tomorrow, your lordship may fix it.
Absolutely no. The last order is of 30/11/2024. You were given the opportunity of filing the objection on 1612. You have not filed. There's not a mention of anything thereafter. Why? What happened on 1612? And you have approached this court after 4 months.
My lord,
5 months.
I will be allowed to.
Withdraw with cost of 1 lakh
My
upon
lord,
you. This type of litigation cannot be allowed.
I will be,
With you, what is your name?
I allow.
Your here is given now. We will attach your what do you call your enrollment number, so that without paying that rupees 1 lakh, you cannot be allowed
My lord,
to
I have-
further go ahead.
My lord, I have also home loan of 26 lakhs, my lord.
So
I am
make it
unable
another
to pay-
one, 27.
unable to pay 1 lakh.
1 lakh is the cost upon you. Impose the cost upon you. And till
It
then,
may be
the
fine, but-
license will be suspended. This
But I
type
have
of
not
litigation done.
Since when I have nothing suppressing, my lord.
No, this is suppression. Why you have moved on 21/4 without stating what has happened on 1612?
My lord,
You have approached this court stating out here one thing, that, and you see, they have passed an order on 30/11 behind my back without giving me an opportunity. The order says that we am not passing any order without hearing the other side. Then also you have approached this court and have not stated what has happened on 1612. When I asked you, you say that you have approached this court. Then I see that on 21/4/2025 you filed this petition. So therefore, there is suppression for which you are equally responsible, being the drafter of the petition. You are the drafter. Tajuddin Sheikh.
At least for a
You are
compliment,
Mr.
I will be
Tajuddin
allowed
Sheikh. No.
to defend
You
myself, my-
are Mr. Tajuddin Sheikh.
I allow.
Alam. Where is he? Tajuddin Sheikh. He also has an enrollment number. I impose it upon him and cancel his and suspend his license till he deposits that before the registry office.
My lord, at least, my lord, one opportunity
For what?
Pardon, my lord, I will,
Hey,
Pardon,
the
sorry, your
enrollment number to लिख लो 210200 and put it in a black ink.
my lord, my lord,
Mr.
20
ILM will learn it
17,
counsel
25, my lord, 17 to 25, my lord, matter is listed. I have not annexed this, my lord. 17 to 20, to 25.
What happened on 16/12/2024?
Gentlemen, my lord, I will, please, lordship, your court.
No, why
Court
haven't you
order-
mentioned in your petition? You have approached this court out here saying that on 30/11 an order has been passed when the case is fixed on air. The court did not say pass any order. The court said, as you have filed the petition, so therefore we will take it up on air. In the meantime, without hearing the other side, I'm not going to pass any order. That is the order you are challenging before this
My
court.
lord, because of, my lord, police has been harassing, my lord. Police
Police has been harassing, will be a case under 226, has nothing to do with this matter. There's no harassment out there. You cannot come up with it. That is an harassment which will come under 226, which have nothing to do. This order does not say that they should be harassed.
In
Don't
that
come
case,
up with this
I-
type of matter. Mr. Ayalam, Lucky. Learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant petition. Taking into account his submission, the instant petition stands closed on withdrawal.
my lord, kindly may not be included in the court.
I've not done it, but I put it in the black ink.
11.
Next time when you appear, you have to be doubly more careful. I have some names out there in my black book.
My lord,
You are one of them now. With glittering look, with golden marks out there.
deeply obliged.
No blades. Yes, Mr. Sharma, what are you challenging?
Under the order of, under.
Huh?
Who left the house on her own volition by signing the agreement.
What is your order?
What is one annexer? If you not, please 12.
26/9/2024. You are challenging.
Yes.
Considering the facts on it is ordered the offence shall make up heir to the petitioner and her minor child with effect from the date of payment. Per month?
per month.
Where is it per month? Where is it per month?
No, 15,000 would not be for a year, matter.
Huh?
1,000 would not be for a year, matter. It is a-
That is why I'm surprised. Why he has not put it per month? I should put it per month now.
It's per month, it is per month, matter. If they are
What
making-
is your income?
My income is 52,000, matter, but I have a loan of 28,000.
I'm not concerned with your loan. We are
What-
more
whatever
concerned
my
with
let-
here
let
from
me
the
first
finished
check the
statement, it
losses.
appears the installment paid by him is 23,000 and he has around 27,000 at his disposal every month. And this is net gross salary was 50,000, 2024. And now you are challenging in 2025. What is the reason?
Wait, wait, matter, let me first do an XLP matter. Why you? I am bound to give to the child matter.
Huh.
An XLP.
Hmm.
He was married with my other, into rights in August 2020,
Huh?
13. And she left the house matter on 10/11/2013 when I was absent matter. The villagers were called in their presence. She signed, her parents also came and signed, and actually whatever matter, my both the parents are seriously ill. I connected all the documents.
Shekhar Bora. Who is Shekhar Bora?
In the battalion,
In Malik Su.
working in battalion. So no sooner she came after the
Second
wedlock
party
matter,
indeed married the
she
first
found that
party
both the
following
parents are hearing.
instructions of her husband. She chooses to visit her child, Iman, here without regard to her parents. For leaving for her parents, the parents of the second party handed over here to her parents. Which for no complaint to them. Then
Then when she left the house immediately after marriage. Then she would not come. Then I issued a legal notice matter at page 16, NHS C, 21/8/2015. It was absent for about more than 3 years, 2 years. Then
so
legal notice sent.
this is an application for restitution of conjugal rights.
Sorry, it is for divorce.
Huh?
For long absence manner, long desertion is for divorce.
Long desertion. Very well, long desertion, you have filed a suit for the divorce. Now in that divorce, she filed an application. And
Yes,
only an amount of 15,000 has been given. We put it at 15,000 per month. We dismiss it with making it 15,000 per month. There is not a single word here given. This is the fourth.
We will also have to come to the medical documents of the parents.
Where is the minor child?
My child is with her.
Your child.
My child.
So then who is going to take care of the child?
I have committed in my paragraph 8 matter for the child I am bound to pay
Then
to other.
pay 15,000. What is wrong with that?
15,000 I cannot pay. That's why before you
Why?
so otherwise I
12,000
would
you
pay
keep it.
because she left on her own. There was no
And in June 2024,
yes.
by today, your salary have increased by around 10% in view of the increase in the DA.
What increment? Third
In
day.
the DA. So then also this is 15,000, we make it 16,500.
Mother, at least mother.
Absolutely no, this type of matters has to be dismissed. No,
Mother,
nothing doing,
Just
15,000.
bear me. I will not to pass order, madam. Just bear me. What happened? She was married in August 2024, 13. As soon as she came to my house, madam, she found both the parents ailing. Mother is in bed. Number of ailments include neurological problem. Madam.
Okay, as you say so, I can issue a notice, but making it a point that you have to regularly pay 15,000 per month to the respondent,
No, that I am paying.
then you have to pay.
Yes,
And
I-
we will have it
so far,
after
madam,
the
no,
divorce
what I am
matter
on,
is
madam,
over.
only one grievance is there. Lakshmi, kindly bear. I am bound to pay for the child, madam. But
You are bound to pay you for your wife also.
wife, she lives matter for a long time. Doesn't return influence the legal
Not
court case.
necessary. Wait, see the order which I pass. This type of orders is helpful for other people also.
Can you do money make 10,000, madam?
No, you
Yes.
paid that 15,000, I make it 16,500. Why she should not be? your salary have increased by 10%.
Your lordship see my condition.
No, and your condition is, but your loan which you have taken is on reducing balance. So it is coming down.
Let notice go, my lord. Okay, I'll continue.
Notice with, you have to pay this 15,000.
I am paying.
Yes, you have to pay. Heard Mr. Issue notice making it returnable on 4th of June 2025. Steps be taken upon the respondent by way of registered as well as usual. Full stop. The petitioner have assailed the order dated 26/9/2024 passed in Miss Judicial Case number 11/2024, whereby the learned court of the District Judge Nagaon had directed the petitioner herein to pay an amount of rupees 15,000 per month to the petitioner and her minor child with effect from the date of passing of the said order. Full stop. There should be areas also. Recently, a Supreme Court judgment has come that it should be from the date of the application. So we put that also, pay the areas also.
My lord,
No, no,
just
you
note
pay
the-
that
let-
area
let the
also.
notice Just go, my lord.
No,
So, these are
You-
the-
this type of matter, mister,
My lord,
one has to
your
be
lordship
very
is
strict in
kindly,
the-
kindly bear with me.
no,
Kindly bear, no, your lordship is not hearing me, my lord.
15,000 per month. We direct you to pay the areas also from the date of the application. Application filed when?
He
June.
was absent so long, my lord, suddenly after the divorce notice had gone,
Obviously,
then only she came and filed the
areas
Again,
also.
she went away.
This is the recent judgment.
Yes,
Let
I
me
see,
add
ma'am.
that.
And she has already gone back to parents' house. What must matter when a poor man marries
Pusta.
his daughter?
The
that's the
learned
problem.
counsel appearing on behalf of the petitioner submits that the amount so directed to be paid to the by the petitioner is beyond his capacity. And as such, the impugned order dated 26/9/2024, passed in Miss Judicial Case number 11/2024, is required to be interfered with. This court have duly perused the said order, and it surprises this court as to why the order dated 26/9/2024, why by the impugned order dated 26/9/2024, the maintenance have been directed to be paid from the date of passing of the said order and not from the date of date of filing of the application, which is the settled position of law. Mr. R.P. Sharma, the learned senior counsel, submits that he would address this court on the next date. Next. This court further, after taking into account the order, the materials and report, is of the opinion that there is no requirement of any state to the impugned order dated 26/9/2024. This court, upon perusal of the impugned order, is of the opinion that without hearing the respondent, it would not be proper to stay the order dated 26/9/2024 impugned in the instant proceedings. Considering the above, this court directs the petitioner to continue to pay the amount of 15,000 per month to the respondent for her interim maintenance till the next full stop. Till any further orders are being passed in the instant proceedings. Full stop. This court also, having taken note of that the respondent herein is a lady who had otherwise no source of income, permits her to apply for legal aid for her representation before this court on the next date.
How many?
Well. That time you should have withdrawn this type of orders with more. Yes, Mr. What is this?
Page number
What are you challenging?
dot six. My petition.
2012-2024 order. Okay, what is it? Isn't it the impugn order? What is your impugn order?
Impugn order is in page number 30.
Huh?
30.
2012. Page 30. What's wrong with the judge to fix the matter after 4 months?
Actually, that hard copy was not shown to the advocate, and those.
No, I'm not on that, Mr. Counsel. The order is of 2012-2024, whereby
It's fixed on, yes, 13, Your Honor, 29 February.
petition is rejected. So your petition has been rejected. Taking time for filing of the WS and
Yes.
fixed 29/4 after 5 months. Why? What is wrong with this judge? Which judge is this?
But it actually, that set of plain concept was served to the.
I'm not concerned with that. I'm concerned with the procedure. How a suit is being fixed after 4 months? Huh? Yes, Mr. Arkev Mia. How is the Kamrup Metro Senior Division
Amingaon.
Kamrup at Amingaon civil judge? Is it in normal circumstances fixed after 5 months? Now, isn't it the most surprising thing? An order is passed on 2012-2024,
Many cases.
fixing it on 29/4/2025.
Yes, many other cases also.
Huh? This is going on. Then what was the point in rejecting? Hello, we allow your petition right today itself. To file your written statement. Which states hard Mr. issue notice. Who is the respondent?
Respondents are the plaintiff.
Issue notice making it returnable on 26th of May 2025. Steps upon the respondent number 1 and 2 be taken by way of registered as well as usual. In addition to that, within 2 days. In addition to that, the petitioner is directed to take steps upon the respondent number 1 and 2 by way of thusly routed through the registry of this court and file an affidavit of service or not before in next date. The petitioner has approached this court challenging the date order dated 2012-2024, passed in title suit number 143/2024, whereby the learned trial court rejected the filing of the rejected the prayer for giving an opportunity to the petitioners who are the defendants in the suit to file the written statement. The learned counsel appearing on behalf of the petitioner submitted that the period of the period of 90 days can only be counted when the plaint, along with the documents relied upon, are submitted to the petition, to the defendants in the entirety. However, certain pages of the plaint were missing, which aspect the learned trial court did not take into consideration. This court further have duly perused the order dated 2012-2024. And it really surprises this court as to why the next date is fixed after 5 months on 29/4/2025 for documents of the issues. Pusto. Taking into account the above, taking into consideration the submissions made by the learned counsel appearing on behalf of the petition, it is the opinion of this court that the petitioner have been able to make out a prima facie case for stay of further proceedings of title suit number 143 of 2024 till the next date. Accordingly, title suit number 143 of 2024 shall remain stayed till the next date. This court further taking into account that a period of 5 months, taking into account that by the impugned order, the suit had been fixed after a period of 5 months, directs the registrar vigilance of this court to call for a report from the concerned court as to why the learned court had fixed the suit after 5 months. And not earlier for documents of the issues. The registry shall also place before this court the pendency of cases before that said court, that is the court of the civil judge, senior division, Kamrup Metro, Kamrup at Amingam, on the next day.
Lordship, some corrections here.
What correction?
Regarding typographical mistake. Lordship.
What correction?
One date is, Your Honor, I have written 29/9/24. It should be 39 words.
I am not going to.
And one word, Lordship, I have written plenty.
File amendment application. If you want to insist, file amendment application.
13.
Yes.
His lordship, the respondent filed a suit for right to interest and confirmation of provision and cancellation of our safety. In that case, they have filed one injunction petition also, and the order was itself passed on 13/11/2024, annexure 3, page 29. Without issuing notice, though the petition was under order 39, rule 1 and 2, showing the urgency, lordship, injunction was granted.
Huh?
Page, lordship.
What are you challenging?
I have challenged, lordship, one petition was filed by the defendants under order 39, rule 7 for inspection of the suit letter.
You are the defendant.
Yes,
Then
that was rejected.
why?
Against that, lordship, defendant number 1, our vendor filed written statement saying admitting the case of the plaintiff.
Where is your petition?
Impugn order, page 83.
Where is your petition?
Petition, lordship, annexure 7, page 76.
Page?
76.
It is Obviously, order 39-7, why you are filing, this is not a petition under order 39-7. 39-7 is for the purpose of conserving the property, isn't it? What is the language used in order 39-7?
Order 39-7 says, Lordship, the court may, on the application of any party to a suit and on such terms, is as it thinks fit, make an order for the detention, preservation, or inspection of any property,
Why?
which is the subject matter of such suit, or as to which any question may arise there. So I am saying that, Lordship, we have purchased a plot of land by registered sale deed from defendant number one, and defendant number one being the cousin brother of plaintiff, he admitted the case of the plaintiff after selling the suit land. He's saying that he has not sold out the suit land, we have done some fraudulent activities. So learned trial court held that as already defendant number one might enter the case of the plaintiff, so I have no case, so this petition cannot be allowed. Findings, your lordship will find page 93. From page 92, last paragraph.
Now, why it was rejected?
Rejected from page 92, your lordship will
I
find.
read it.
Only that my vendor admitted that he had no title, he had not executed the sale deed, it was
You are
fraudulent.
the defendant number 2 to 14.
Yes.
So
We are the
your vendor is defendant number 1.
Vendor is defendant number one.
So your defendant, in his written statement, he has stated that he had no title.
Title, we have
And
fraudulent.
he had no possession except in the northern part of the suit land.
He
To
stated,
the extent of 1 katha,
he admitted about the registration of the sale deed, lordship, but he stated that we have fraudulently stated some other lands in the sale deed.
so the defendant number 1 is also against you.
Yes. He is the cousin brother of the plaintiff, lordship. After selling the property, now he's saying he has not sold out the property which.
Now, what do you want?
For inspection of the.
Why?
Before injunction, lordship, for adjudication of the matter is the injunction petition, lordship. The
What is the injunction granted?
defend, we were restrained in disturbing the peaceful possession of the petition plaintiffs.
Where is the injunction order?
Page 42.
Now you say that you are in possession.
We are
They
constructing
have
our-
given an ad interim injunction, exporting.
Yes. The petition was filed under Order 39, Rule 1 and 2. But Lorna Trial Court held that there is urgency, so Lordship, page 41, cites upon perusal of the documents available in the record, second paragraph, Lordship, as well as the original suit coupled with the facts and circumstances of the case, it appears to me that the petitioner's plaintiffs could be able to show urgency for grant of ad interim temporary injunction, dispensing prior notice under Order 39, Rule 3A. But their petition was under Order 39, Rule 1 and 2. That
But
which
there might be a prayer out there.
prayer is there, Lordship, by dispensing.
No, or notice. This delay would not have, will have an impact, no? Now, what has happened to the
I
injunction
have
proceedings?
paid, Lordship, for stay of the case, exemption case. Title suit, it can be proceeded. We have already filed written statement, written objection, and this petition on the same date, 16/1.
But why have you approached now? Why should they stay today?
Lordship, this
This
case,
is an order of 19/2/2025.
yes, Lordship, we have obtained certified copy in the month of March, Lordship.
You have obtained March. We are in the month of April. Tomorrow is May.
We have applied 22 and it was,
No, it is okay. You have applied lately. I'm not
Okay,
concerned, but
thereafter
why
we
should
have
I stay?
Lordship, thereafter we have informed the court that we are going to.
It doesn't mention anything about the certified copy prepared on 24/2/2025. That
24, we have obtained some of the certificates.
certified copy is of 24/2/2025. Then why you have moved so late? Why should I stay? No stay. This becomes a useless formality.
Injunction, Lordship, this case may kindly be stayed,
No.
otherwise, Lordship, it will proceed.
No, obviously no, because of the fact that you have come so delayed. You've
Lordship,
come after 2, 3 months almost.
I
2
have
months.
filed it on 8/4, Lordship.
Then 8/4 also, why? You have got the certified copy on the 24/2.
Lordship, before that, we tried to obtain the wakalat
No,
number
we
of all the
also
dependents, but Lordship, later on, as they are residing over different places.
Okay,
Later, we have files with only one dependent.
absolutely no. Sorry. Issue notice making it returnable. Why performer 22/23 is who?
Lordship, they are proper.
They are the co-defendants. We don't require them.
Lordship may issue notice if they did not appear.
But this will only delay your thing. I'm not going to grant a stay. You want it very well, serve him. Issue notice making it returnable on when? 2nd of June 2025. Steps be taken upon all the respondents by way of registered as well as usual. You want to take steps by trustee? The petitioner is given the liberty to take steps upon all the respondents by way of trustee routed through the registry of the spot and file an affidavit of service or not before the next date. The petitioner herein has approached the spot challenging the order dated 19/2/2025, passed in Midway case number 31/2025, arising out of Midway case number 300/2024, whereby the court of the civil judge, senior division number 1, Kachar at Silchar, have rejected the application under order 39/7 of the court filed by the petitioner, who are the defendant numbers 2 to 14 in the suit. Defendant number 2 to 14, opposite party number 2 to, who are the defendants number 2 to 14 in the suit, as well as opposite party number 2 to 14 in the injunction proceedings. It is the case of the plaintiff, petitioners the petitioner that they are actually in possession of the suit land. And it is under such circumstances the local inspection was sought for. The learned counsel submits that the local inspection has been, the application seeking, admits that the application have been erroneously rejected by the learned trial court for which interference is required. This court duly takes note of that the order was passed from 19 to 2025 and the certified copy was obtained on 24 to 2025. But however, as approached this court after almost 2 months, after almost 2 months, under such circumstances, without hearing the respondents, it would not be prudent to pass any interim order. Considering the above, so the interim order shall be considered on the next day.
Written statement of certified copy we have obtained on 11/3 annexure.
No, kindly see down below.
Worship annexure 5. Kindly
Which,
see along.
which,
Written statement obtained on 11/3, Lordship.
I'm not concerned, kindly see this page.
Some of the documents of.
I'm not concerned with that. We don't require the other documents. Are you not a party to the suit? Then
Written statement also we have obtained.
I'm
the
not
certified-
concerned. The order is free. Kindly see prepared to be a true certified copy, page 94, 24 to 2025.
Is order.
We are concerned with the impugned order. We are not concerned with the rejection of a plaint.
Written statement, Lordship, we have applied in the month of February, but they provided the.
You have a written statement. Don't you have it?
Certified copy we have applied,
But
Lordship.
is it required to enclose the certified copy? If you have an urgency, you should have moved immediately.
14.
But the arising out of an execution proceedings, here the decree holders are at loggerheads among themselves. If the lordship takes up page 50, that was a judgment passed by your lord. Page 50. Lord finds the appellant was substituted and there were as many as 4 substituted legal aids. Now, this was against the tenant for eviction from a particular shop premises. Now, after this decree, my lord, the lordship marks 1.1 was Rupchand Kucheria and 1.4 was Indra Devi Surana, who is the petitioner before your lord. Now, my lord, our version is that after the judgment was rendered against the tenant, there was an understanding that this particular shop premises should come to me as a part of the family division. Now, thereafter, Lord, the tenant who was sought to be evicted, there was an understanding and he attorned me as the landlord. Now, after that, we say that this is because of this particular arrangement, the initial execution case was filed only for recovery of the areas. However, there was an amendment introduced and the decree for recovery of possession was also incorporated. Now, meanwhile, my lord, there were several other proceedings, including a probate title suit and a partition suit among the decree holders. Thereafter, my lord, the tenant moved an application.
Who are you?
I am the decree holder 1.4. After that,
Now, there are two judgments delivered by me. Right. One where I have said that for vacating within 6 months. Thereupon, another case was filed by the tenant to the effect that the property in question has now again been given to me by one of the decree holders. And as such, I have a right to continue. Was rejected by the trial court. And the matter came up before me, I again dismissed. Now what?
now, my lord, after that,
Has the possession been handed over by the
the
tenant?
tenant has vacated. Tenant has vacated. Now,
What is the dispute?
the difficulty is, we went to the executing court. We informed the court that the tenant is no longer there. It is today in my possession. So therefore, you suspend the warrant of delivery. Because in the garb of executing the decree against the tenant, the decree holder 1 may now evict me because the tenant is no longer there.
Now, my lord, that application was moved, that application was not taken in record. We moved the district judge also, that we've already filed an application and there is a warrant of delivery hanging over our head. So let that application at least be considered. But that application has not, also not been considered. Prior to that, my lord, I've issued another order. We went before the court. We went before the court and we said that this decree should be treated as satisfied because I am one of the decree holders and he had surrendered possession to me. Now is the tenant under. That application has been rejected. That is placed as an impugned order here. But the more serious grievance is the subsequent application that we filed saying that the tenant is also no longer there. So therefore, but now if you execute the delivery of warrant, you will indirectly.
No, how do you solely have the right?
I do not. Now, man, I do not. I'm not saying that I solely have the right. That is subject to proof in the suit and.
Forget about that. This is the second round of litigation after my dismissal of the second
Right.
round.
Now, my lord. Now, my lord.
How much cost on you now?
My lord, I'm one of the
Filing
legal.
of the-
My lord will file.
We'll ask the OC as to who is in possession.
Very well.
Find out.
Very well. Yes, yes.
Ask
Let
the
them-
OC to find out who's in possession. In number 57. Huh? During this period, the defendant shall remain in possession of the behalf of the plaintiffs and shall not do any act or acts which may affect the rights of the plaintiff of the suit premises in any manner. No, then I have passed again another
Yes,
order.
yes. That is at 140.
I categorically say an
That the-
application was filed by so and so, this court have duly heard by so and so. On the- You have allowed them. Only come to page 145.
I've seen that. The collusion, your lordship has inferred collusion. Now, my lord, my lord, we'll come to paragraph 18 of my application.
I'm not,
My lord,
nothing is that. This is your second, now earlier the tenant was coming, now you are coming.
my lord, only point of law involved here.
There's no point of law.
There is one, I'll just point out.
You have filed a suit.
I filed the suit, my lord. There's an ongoing contest among the brother and the sister. Now, in the midst, yeah, amidst all this, my lord, if one decree holder executes the decree, as against Order 21, Rule 15 clearly casts an obligation on the executing court to ensure that the co-decree holder is not put to prejudice.
What is your suit for?
Suit for partition.
You got any injunction?
No, my lord.
Well, but what are you challenging me?
I'm challenging the order and the non-consideration of the application which I
order?
filed
Which
subsequently.
order?
My lord finds it at page 167, and my moot grievance is non-consideration of my
No,
application
which,
at
which order?
167.
157 is not order.
167. Even my basic submission is given this scenario, Lord, the executing court
Rightly so. Very well. Drafted on.
Lord will kindly have page 180.
See the soup message? You take a photograph, na?
Yes. Page 179.
This one.
Yes.
How do you get possession?
Because I am also a court decree holder, my case is, my lord, my case is that
You were never in possession.
I was never in possession. It was
Then
always.
how did you get the possession?
Lord, I got the possession.
Because of a decree passed by because of the judgment passed by this court.
Yes.
Then, if you were in possession on the basis of that, you had a right, whatever maybe you couldn't have unilaterally taken over. The possession has to be taken by the court and thereupon the court may decide.
Exactly the same argument, my lord. I will make in.
So, for the court, I direct, let the court take over the possession of the premises and keep it attached till the disposal of the.
I'll consider.
No, understood, but Mr. Counsel, you were fighting against the tenant. Okay. So therefore, the question is, what the petitioner was trying to do. Petitioner was not trying to do, she has no business out there, I also know. That tenant out there had clandestinely entered into an agreement with the petitioner and wanted to take over and continue with says that I had handed over in terms with the undertaking given, and as such, now a fresh tenancy has been given by him. That is what the petitioner said. Now that I have rejected it. And I said that let the district judge pass the appropriate orders to that effect. But I did not interfere with the order passed and get put to challenge before the court under 227. I've also recorded at page 147 or so and so that this appears to be a clandestine action on the part of the tenant along with the petition. Now this is the place where, this is the page, annexure 18 is the shop room. Okay. Now the shop room concern is, now it is a dispute between you and them. So let this thing remain attached. Under no circumstances this should be allowed. And then you point out amongst yourself as regards the suit or whatever may be. Understood, but what is your right? You, Mr. Counsel, you have your own right. Unless there is a partition. But unless there is a partition, you don't have a right. So let this shop remain attached with the court, and under no circumstances
a court will appoint a receiver out. Understood. Therefore, my question is, let this be attached and kept under the receiver of a court. Once it is being done, then the tenant is outstayed. You see, this is a clandestine move made by Mr. Borun Deka. He has made a clandestine move along with this. So therefore, what is required is, take over this, put it under the receiver, the court will appoint the receiver and keep it under the court's stay. And it shall not be allowed to be opened till the dispute between both of you is settled in accordance with law. So then, he does not get the finance. Now, who is the financing Mr. Decker's client? It is the tenant who is doing it. This is another attempt being made. So we dismiss this with a cost of 1 lakh upon Mr. Decker. That is 1 lakh upon Mr. Decker, and also deprecating fees or reprimanding him for his conduct in moving this type of.
My lord, will allow me to place the law. Two judgments and things.
Absolutely no. You go to Supreme Court and show all these judgments. No, nothing doing. I'm going to dismiss it with cost of 1 lakh
Will
upon you.
record my submission.
No,
My lord,
No,
is,
no, no.
my lord is inferring that it is a fine. It's a proxy by the tenant. Now, if your lordship allows me to take your lordship through the record.
that's not necessary.
Lord, through the record, my lord, this is
No,
an
not
ongoing
necessary.
litigation, the 2 to 3 litigations between the brother and the sister.
So what? How on earth did you take possession?
My lord,
How
can-
on
how
earth?
can they
No,
maintain their
the
execution
question does not
application?
arise. How on earth you took the possession? You could not have taken over the possession by yourself, entered into this agreement with so and so.
My lord, will allow me to place it, my lord,
No.
there are similar judgments.
No, wait to the Supreme Court. Wait. This is not the manner in which the court's undertaking which is being given is being
My lord, the
violated.
executing court cannot side with one decree holder. Cannot side with one decree holder.
That is why I'm saying, neither you nor him shall run it. It will be closed forever till the dispute, the partition suit is disposed of, and the locks will be kept with the court. And we dismissed it with a cost of rupees 1 lakh upon you reprimanding. But thing good is, the court did not pass that order of receiver and passed. 102%. Therefore, this is a case of extreme abuse of the process of law. Taking advantage extreme abuse of the process of law. The petitioner herein has approached this court challenging an order dated 6/2/2025 whereby an application filed by the petitioner under section 47, read with section 151, was dismissed by the learned trial court. By the learned executing court, that is the court of the civil judge, senior division Bongaigaon, in Mize case, which was Bongaigaon. The question arises as to whether this court should exercise its revisional jurisdiction against the said order. Thus, supervisory jurisdiction against the said order. This court have specifically inquired with Mr. B. Decker as to whether he would only as to whether the petitioner would confine the jurisdiction under Article 2 to 7 of the Constitution, or would like this court convert the instant proceedings to a revisional jurisdiction. So Mr. B. Decker submitted that the petitioner would confine its case within the four corners of the supervisory jurisdiction. So taking into account the above, this court observes that Section 115 of the code observes that when an application under Section 47 is dismissed, rejected, the revisional jurisdiction of this court, there's a revisional jurisdiction conferred upon this court under Section 115 of the code. However, as the petitioner seeks to confine its submissions only to the supervisory jurisdiction, on that ground alone, the instant petition is required to be dismissed. Be that as it may, this court would like to take note of the manner in which the present proceedings have been initiated. The predecessor in interest of the petitioner and the respondents herein, one Mulchan Kuchera, had filed a suit before the court of the Munsif at Bongaigaon, which was registered as title suit number 2/2000, seeking eviction of a tenant, seeking eviction of the defendants who were admittedly tenants of the predecessor in interest of the predecessor in interest tenants of Mulchan Kucheria, since deceased. The learned trial court, that is the court of the Munsif at Bongaigaon, by the judgment and decree dated, what is that? 5/8/2010, decreed the suit in favor of the plaintiffs. Was the tenant, who was the defendant, being aggrieved, preferred an appeal before the learned court of the civil judge Bongaigaon, which was registered and numbered as title appeal number 35/2010. The learned first appellate court, by the judgment and decree dated 5/11/2013, affirmed the appeal, affirmed the judgment and decree dated 5/8/2010. However, interfered with a finding as regards defaulter in payment of rent. Be that as it may, as one of the grounds of eviction, of ejectment, was found in favor of the plaintiffs. The appeal was dismissed, thereby affirming the judgment and decree passed by the learned trial court. The tenant thereupon filed another application, filed an application under section 115 of the code before this court, which was registered and numbered as CRP number 77/2014. This court, by an order dated 3/11/2016, reversed the judgment of the learned first appellate court on the ground of non-compliance to the provisions of Order 41, Rule 31, and remanded the matter back to the learned first appellate court for recording the fresh decision on the issues by discussing the evidence available on record and keeping in mind the principle embodied in Order 41, Rule 31 of the code. In pursuance to the directions passed by this court, in CRP number 77/2014, the learned first appellate court, by the judgment and decree dated 22/9/2017, dismissed the suit being aggrieved. The plaintiffs approached this court by filing a proceedings under section 115 of the code, which was registered and numbered as CRP number 19/2018. This court, by the detailed judgment and order dated 5/6/2023, interfered with the judgment and decree dated 22/9/2017, passed by the Court of the Civil Judge Bongaigaon in title appeal number 35/2010, and affirmed the judgment and decree passed by the learned trial court by holding that both on the ground of defaulter by holding that the defendants in the said suit, being title suit number 2/2000, were defaulter in payment of rent, as well as the plaintiffs had bona fide requirement of the suit premises. So it is very pertinent to mention at this stage that during the pendency of title suit CRP number 19/2018, the original plaintiff expired and he was substituted by the petitioner as well as the respondents herein, who were the legal representatives of the plaintiff. This court further finds it relevant to take note of that upon confirming the decree, upon decreeing the suit in favor of the plaintiff, the plaintiffs were therefore entitled to recovery of cast possession by ejectment of the defendant of the said suit. counsel who represented the defendants in title suit number defendants in CRP number who represented the tenant in CRP number 19/2018, 18 submitted before this court at the time of passing the impugned order, passing the judgment and decree. Dated 5/6/2023. That as the petition, as the tenant was carrying on business over the suit premises for a considerable period of time, some time may be granted as it would be, as it would cause serious irretrievable injury to the tenants if they are immediately evicted from the suit premises. Therefore, considering the same, granted 6 months' time to the tenant to vacate the suit premises, provided they submitted an undertaking before the trial court within 26/2023 to the effect that they shall vacate the suit premises within a period of 6 months from the date of the judgment. That is on or before 6/12/2023. It was also observed that failure to submit any undertaking within the period, the defendant, the petitioners who were the plaintiffs would be entitled to initiate execution proceedings for evicting the defendants. What subsequently followed thereafter reminds this court of the judgment of his lordships Krishna R. J. rendered in the case of T. Arinvan Dhanam versus T.V. Satyapal and another, reported in 1977, 4 SCC 467. Wherein also, wherein also taking advantage of the time being granted to vacate the premises, the tenant to recourse to litigative acrobatics in order to nullify the judgment and decree. Similarly, in the instant case, the tenant, though submitted the tenant who was the defendant in the suit, those submitted an undertaking that it would vacate the suit premises on or before 6/12/2023. But instead, entered into a clandestine negotiation with the petitioner herein. Entered into a clandestine uh, surreptitiously, clandestine, the tenant who was the defendant in the suit surreptitiously entered into some arrangement with the petitioner herein, thereby not only to nullify the judgment and decree passed by this court, but also to frustrate an undertaking being given before the trial court which had the force of law. The record further reveals that when the execution proceedings were initiated, on the ground that in spite of the undertaking being given, the possession was not handed over to the decree holders. The petitioner herein, the tenant joined together with the petitioner to object to the execution proceedings on the ground that the tenant had entered into an fresh agreement for tenancy with the petitioner after handing over the possession of the suit premises to the petitioner. It is noteworthy to mention that the undertaking so given, which ought to have been given by the tenant, was for handing over the possession of the suit premises to the decree holders, who were the petitioners in CRP number 19/2018, and not solely to the petitioner, solely to one of the petitioners of the said proceedings, that is the petitioner in the instant proceedings. This led to the second round of litigation, which also came up before the court. This led to the second round of litigation. Inasmuch as the respondents herein, who were also the co-decree holders, were shocked at the clandestine and surreptitious activities of the tenant with the petitioner, for which they sought for amendment of the execution proceedings. This amendment was allowed, which was put to challenge before this court by invoking the supervisory jurisdiction under Article 227 of the Constitution. This application was filed by the tenant objecting to the amendment of the execution application. This court, while dismissing the said application by the detailed judgment and order dated 27/3/2024, with an observation that the action on the part of the tenant with the petitioner herein amounted to deliberately denying the benefits of a lawful decree to the decree holders. It was also observed that the action of the tenant in concert and in collusion with the decree holder, one of the decree holders, was nothing but a subterfuge in order to deprive the decree holders of the fruits of the decree. When the said judgment and order was passed, dated 27/3/2024, in CRP IO number 92/2024, the tenant then, in order to further deny the decree holders of the fruits of the decree, filed an application through the petitioner this time under section 47, read with section 151. For closing the execution case after recording satisfaction of the decree, inasmuch as the petitioner had entered into a clandestine, petitioner had entered into an agreement with the tenant. This application was registered and numbered as MISJ case number 56/2024. The respondents herein filed their objection. Stating inter alia that a judgment and decree passed by this court on 5/6/2023 in CRP 19/2018 was clear that the decree holders can maintain a application seeking execution if the possession of the suit premises was not handed over. And as such, the question of dismissal of the said application on being satisfied, the foreclosing of the execution application on being satisfied does not arise. It is under such circumstances, the learned trial executing court, after hearing both the parties, passed an order on 6/2/2025, whereby the application under section 47 of the code read with section 151. Section 47 read with section 151 was rejected, and therefore the petitioner has approached this court. Before further continuing, this court finds it now relevant to take note of the contents of the application filed under section 47. It is the case of the petitioner that her father, late Mulchand Kucheria, during his lifetime, had formally effected a settlement of partition amongst them in respect of all his properties, amongst his legal representatives, amongst his legal heirs. And it was specifically, and he further stated that the ownership of the shops and the residential portions let out to the existing tenants at Bongaigaon, that is Bongaigaon store, and one Boris Shankar Sharma would be given to the petitioner as her share. So that she can earn the rental income therefrom after entering into a new agreement. However, the said aspect was only verbally said, but that was not put down in black and white. It is, however, very pertinent to mention. When did he die? Mulchan Kucharian?
5/1/20.
5/1/23. It is very relevant to take note of that Mulchan Kucharia expired on 5/1/2023, much prior to the deed, but much prior to the judgment and decree dated 5/6/2023. Whereby the decree was passed in favor of the plaintiffs in title suit number 02/2000, which included the petitioner as well as the respondents herein. It was further stated that on 13/11/2023, the judgment debtor was, that is the tenant, had handed over the possession of the suit premises to the petitioner. And on that very day, the petitioner entered into an agreement with MS Bongaigo Store for a monthly rent of rupees 12,000 with a condition for enhancement of monthly rent by 10% at the expiry of 3 years. And the same was agreed to have effect from 1st day of November 2023. You filed a you filed a probate, no? It is also very relevant to take note of that on the other hand, the respondents herein, more particularly the respondent number 1, had filed a probate case, being Miss Probate case number 25/2023, seeking probate of the will of late Mulchand Kucheria. Wherein, and as per the said will, the tenanted premises was given to whom? Mr. Tenanted premises given to whom? Huh? Was given to defender, the respondent number 1 and 2.
Yes.
To the respondent numbers 1 and 2. The petitioner, however, have not challenged the said probate proceeding. Probate.
We have an order also for preserving the subject.
Huh?
We have moved an application along with the objection. We moved an application. If this is what is happening, the probate court has already passed an order that the subject matter of the will should be preserved.
Will should be preserved means how? To allow that the tenant to run.
It has not said anything specific. We said that there is
Let
a
me come back. I'll come and pass the remaining. Now it has gone to 1.25 lakhs. 1 lakh is to you. And I will, and Mr. Deka, I'm also reprimanding your conduct. And did you file the probate? Oh, 70. And when did they file the objection? Is very relevant to take note of. That the misprobate case number 25 of 2023 was filed on 4/7/2023. And the petitioner herein, after receipt of the said summons in respect to the said case, filed objection in the said probate proceedings on 14/11/2023. In the meantime, having due knowledge that a probate proceedings have been filed in respect of a will which had been executed by the father of the petitioner and the respondents, the petitioner, in order to nullify the said probate proceedings, entered into a purported agreement with the tenant. This aspect of the matter has vital importance to the instant proceedings. Next. It is further seen that on the basis of the fresh agreement entered into on 13/11/2023, purported fresh agreement entered into on 13/11/2023, the petitioner sought for dismissal of the said execution proceedings. In the instant petition, though the said application under section 47 have been filed, but the enclosures to the said petition have not been filed. During the course of the hearing, the court inquired into as to whether that purported agreement dated 13/11/2023 was a registered agreement or not. The learned counsel raised the agreement. The learned counsel appearing on behalf of the petitioner submitted, it is not a registered agreement. That the said agreement, the purported agreement dated 13/11/2023 is not a registered agreement. This court have further duly taken note of the order dated 6/2/2025, wherein the learned executing court, after duly taking note of the objections so raised, duly taken note of the contentions of the application under section 47, as well as the objections filed by decree holders. Into a categorical finding that the petitioner herein had unauthorizedly and illegally claimed herself to be the owner of the decretal premises, claiming it to be her share in her father's property on the strength of a alleged verbal will of her father, giving her ownership of the said decretal land. The learned executing court further observed that the judgment debtors are to be evicted from the decretal premises, and as such, the execution case being title execution case number 4 of the 2024 cannot be closed on account of the tenancy agreement. In the backdrop of the above, this court have heard the learned counsel appearing on behalf of the petitioner as well as the respondent. Mr. B. Dekar, the learned counsel appearing on behalf of the petitioner, had submitted that the petitioner herein, being one of the joint decree holders, have leased out the seats, leased out the decretal premises by an unregistered agreement dated 13/11/2023. And as such, till a partition is not effected from the question of allowing the decree holder to further, the other decree holders to further pursue the execution proceedings does not arise. He referred to the judgment of the Supreme Court in the case of Jagadish Dutt, isn't it? That is your judgment.
This also.
What else? Sunplan. That is the judgment of Justice Fukon, 93. These are the two judgments. He therefore referred to the judgment of the case of the Supreme Court in the case of Jagadish Dutt and another versus Dharampal and others reported in 1993 3 SEC 644, as well as the judgment of the coordinate bench of this court in the case of, what is that?
Vipul Bihari Nag versus Mehboob.
You have a copy of it? Vipul Bihari Nag versus Mohammed Mehmood Hussain, reported in 1993 1 GLR 336. Per contra, Mr. S. Sansati, the learned counsel appearing on behalf of R. Sansati or S. A. Sansati, the learned counsel appearing on behalf of the respondent, submitted that this is the case where taking benefit of the decree passed by this court, thereby granting 6 months' time to the judgment debtor to vacate the premises subject to furnishing and undertaking. The judgment debtor have indulged in various forms of litigations in order to deny the fruits of the decree. He referred to the judgment and decree dated 5/6/2023 in CRP number 19 na, public 2018, wherein this court categorically observed that the judgment debtor cannot be permitted to do any act or acts which may affect the rights of the plaintiffs over the suit premises in any manner. Pusto. He therefore submitted that in order to circumvent the said judgment and decree passed by this court, which had attained finality, and also the undertaking so furnished before the learned trial court, the judgment debtor, instead of entering into an agreement, have entered into an agreement through one of the partners of the judgment debtor, which is apparent from the application filed by the petitioner under section 47 of the code. He therefore submitted that in the instant case not only should be dismissed, but exemplary cost should be imposed upon the petitioner. He further submitted that the instant proceedings is nothing but a proceedings filed at the behest of the judgment debtor to continue to remain in possession of the suit premise of the decretal premises beyond the period even permitted by the decree passed by this court. I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration to the materials on record. Can there be a verbal will? Can there be a verbal will?
There cannot be.
This court at the outset inquired with the learned counsel appearing on behalf of the petitioner as to whether any verbal will can be probated, can any right be conferred on the basis of a verbal will. Because the learned counsel submitted that the provisions of the Indian Succession Act 1925 do not provide for such, do not recognize such verbal wills. This court further takes note of that the judgment and decree was passed by this court on 5/6/2023. Whereby a decree for eviction of the judgment debtor was decree for eviction of the judgment debtor was whereby a decree for ejectment of the judgment debtor was passed. This court, however, taking a humanitarian point of view, have permitted the judgment debtor to remain in possession of the suit premises for another period of 6 months, subject to an undertaking given that they would vacate the suit premises on or before 6/12/2023. The judgment debtor furnished such undertaking and furnished such undertaking before the learned trial court, which also included that the judgment debtor shall not do any acts which would affect the rights of the decree holders, which not only included the petitioner, but also the respondents who were also co-decree holders. Full stop. In spite of such an undertaking given by the judgment debtor before the learned trial court, which had the force of law, force of an order, the judgment debtor, one of the partners of the judgment debtor, entered into an agreement with the petitioner. Full stop. Purported agreement with the petitioner on 13/11/2023. This court further takes note of that late Mulchan Ucheria had made a will during his lifetime, and the said was put to probate by filing a misprobate case number 23/. Probate case number 25/2023, which was filed on 4/7/2023. The petitioner, having received the said probate application, received the summons on 14/11/2023, had submitted objections to the said probate application, meaning thereby the petitioner, knowing fully well that there was a will executed by the father of the petitioner, and which was put to probate in misprobate case number 25/2023, had entered into an agreement, an unregistered agreement on 13/11/2023. There is nothing on record to show that the petitioner had rights over the said decretal premises until the will is not declared by the court of law to be invalid. The petitioner could not have claimed that the petitioner had any right over the suit premises, over the decretal premises, had sole right over the decretal premises. In this context, let this court take up the judgment of the Supreme Court in the case of Jagadish Dutt and Supra. the facts of the said case are completely different in as much as after the ejectment proceedings was put to it, after the ejectment proceedings was passed, there was a transfer by way of a registered instrument in favor of the judgment debtor by one of the decree holders. In the instant case, what is being transferred is on the basis of an unregistered agreement, which cannot be taken judicial notice that there is a creation of a tenancy as it is beyond the period of 1 year. Beyond the period of 1 year. 1311. How much? What is the 1311 document? What is the period of that agreement? That they are not enclosed. You don't have it. It is there in the earlier file. Where's the earlier file? You don't have the earlier file.
I don't have copy.
It's an unregistered document and as such has no and cannot be taken judicial countenance. Further to that, the petitioner having no right over the suit premises till the probate, the will in question have been declared to be invalid in respect to the objection so filed by the petitioner. The petitioner could not have entered into the agreement with the judgment debtor. The entering of the agreement with the judgment debtor by the petitioner further is contrary to the decree, judgment and decree dated 5/6/2023 in CRP case number 19/2023, as well as further the undertaking which was submitted by the judgment debtor before the learned trial court. These distinguishing facts distinguishes the present case from the case before the Supreme Court in the case of Jagadish Dutt Supra. This court further takes note of the judgment of the coordinate bench of this court in the case of Bipul Bihari Nag, wherein the observations were made by the coordinate bench was in respect to Order 21 Rule 15, which permits that 15 to the effect that the said provision permits one of the co-decree holder to file an application for execution for the benefit of all the decree holders and not for the co-decree holder himself. The said judgment, however, in the opinion of this court, does the ratio laid down in the said judgment, however, in the opinion of this court, does not have any application. Considering the above, in addition to that, this court further finds it relevant to take note of that by way of an application under Section 47, the petitioner herein cannot raise the issue of an inter-dispute, cannot raise the issue of a dispute amongst the co-decree holders, which have been sought to done by filing the application, which is also the ratio in the case of Jagadish Dutt Supra. Considering the above, this court finds no ground to interfere with the order dated 6/2025, for which the instant petition stands dismissed. This court further takes note of that this is a case where there is a gross abuse of the process of the court by the petitioner. That too, at the behest of the decree holder, who has flagrantly violated the undertaking given by this given pursuant to the judgment and decree passed by this court on 15/5/6/2023. Considering the above, this court imposes a cost of rupees 1 lakh upon the petitioner, whose the said cost be deposited shall be deposited by the petitioner before the executing court on the next date so fixed.
Item 45, fixed at 2 p.m.
Yes, what has happened? Within statement filed. What is their stand?
Paragraph 4 and 12, my lord, of the performance.
We have filed it.
Earlier official, we have also obtained the certificate copy. Paragraph 4, my lord. 12. These proposals, all are in the parties to the compromise.
Now, Mr. Mishra, with this written statement filed by the performer defendant number 4, 5, and 6, where they are not inclined for partition. That's okay. That is another reason, whether the reasons are justifiable or not, that is another thing. But without there being a partition, there cannot be a sale by him. Yes. Yes. You have filed that, no? Compromise decree. Ah. Yes. One. Yes. Yeah. Page. Ah.
Who are you? You were also there, party there? Huh? You were the party to the settlement? Yeah, Ashit Ranjan Bhode. Yeah, that is you. Yes, 27C. Since defendant numbers so and so are not parties to the terms of the plaintiff, to be entitled to proceed with the suit as against the defendants. In terms of the terms and allocations have been made to all those non-participating defendants who are not party to the suit. The allocated portions as mentioned in the terms will be made written as is where it is. Then now let us see, this is the terms. The terms are binding upon the parties, which will include the defendants, all the defendants, the defendant number one to all the performer. They will be all bound by these terms. Whereas you are not bound because you have not accepted the terms. So this is what I want to. Let us see.
20% means from? Okay. So they are also party to the agreement. The agreement is with the plaintiff and four parties. That those areas to a particular specific allotted to for particular lot should be within 180 days from the date of finalization and with valid notice for possession and for mutual themselves in respect to their physical possession. Until that period of actual possession, the parties have agreed to obtain joint allotment of their remark. So we need to say, irrespective of whatever may be, similar to section 44 of the Transfer of Property Act, they have a right in respect to 40% or 60% from that age. So they can sell off their share. And once they sell off the share, then you can very well participate in the partition amongst the others also. So your prayer is, your prayer number A is that declaration that the plaintiff is entitled to specific performance of the contract under agreement between the plaintiff and the defendant, get the sale deed executed and registered and recover possession of the contracted land on partition of 60% of the schedule A land in favor of the plaintiff by deposit of the balance consideration. But without there being a partition, first you have a right to seek declare specific performance as per the specific relief act. And as per section 22, if I'm not wrong, you can ask for partition. So your suit is for declaration of right, declaration for specific performance, you are entitled for specific performance, as well as for partition. So therefore, whether they do the partition now or later on, you are not concerned. You say that you sell me as it is the 60%. And thereupon, you step into the suit and you do what it is. Now, page 22, how do you take care of this line? The vendors have agreed to get it separated and then convey the same to the vending. Paragraph 1. How do you take care of that situation? I'm ready. They are in possession, there's no quarrel. See, whether they are partitioned or not, once it is being allotted, they are in possession. They may be in joint possession, whatever may be, they are in possession. Then they agreed to that effect that, okay, they offered it in terms of 22 of the Hindu Succession Act. The right of preemption was given. And once the preemptory right, they have not exercised out there, so they wanted to sell it. So therefore, they are saying that we are taking the south, you take the north. I understand that, but how do you take care of this? How do you explain the vendor have agreed to get it separated, then convey the same to the vending? Now, yes, one thing, they have a right of 60%, you can very well purchase. There's no quarrel with that, you can purchase. Then you can very well ask. But if there is a clause in the agreement that it will happen only after being separated, means after a mutation being or revenue separation being done, then would you have a right, would there be a cause of action now in the filing of it? Or may also be, you can very well submit also that if they don't do it within a particular period of time, you can also seek right under 22 of the specific relief. Now you can very well ask for partition to that effect. You can very well ask. But your second prayer made in the petition, the claim, is the problem which I'm facing. Not happily worded. Or you may very well say that, okay, I'm happy with you give me your share, I will get myself 40. And there is no prohibition on the part to grant you a lesser relief than the relief sought for. No, he is trying to build on 1K that now he wants to sell it to somebody. He'll do one thing. The day, Mr. Dr. tomorrow.
Yes. I have 2, 3 points, man. Additionally, I have to submit some.
Because I have to deal with other matters, other lawyers are waiting. It takes time. One motion matter took a long time. Some other day, then when I'm otherwise ready, means I have to dictate it. I don't think these matters resolved.
Tomorrow is first.
No, I got lots of matters. First, no?
We are in on the conclusion part.
I have
I
already,
have
I
done
have already 21 matters. Second, I have already fixed 12.
Then 8 or 9.
Nine, nine, nine,
9,
12 is Buddha Purnima, Mr.
10.
10, 10th, 11th, 12th are holidays.
Yes.
Holiday. 15. 15. Okay. No, no, I'll finish it off at the top of the list. 15th at the top of the list. Okay. Today I don't have the time. I don't have the luxury of the time. Other councils are waiting. So I have to pass some other thing. So the matter having been was heard, matter have been heard, substantially heard. was, The Dr. City Council appearing on behalf of the appellant submits that you would like to give up for the list of matter on 15 May 2025 at the top of the list.
Actually, sorry to mention, I remember 16 and 17 madam. They are paying for liquidation madam. Because some personal difference madam. They will let it be, it's enough day after tomorrow madam.
15.
16 and 17.
Huh?
16 and 17.
15 and 17.
I have taken the confirmation the other side also madam.
I am to take 15, 15 not taken. Huh? Let me take up 15, then I'll adjourn your seat. Let me take up 15.
Item 15.
This is the landlord tenant. No, this is. Yes, why you were not present yesterday when the matter was called? That landlord tenant matter? Your name was glaringly shown in the public.
I think it's down.
That matter where Mr. S. Na KK Pukas.
I remember, but some point.
On the issue of pertaining to defaulter and
And the bona fide
bona fide
requirement
requirement. Bona fide
reverts.
means
Reverts. I'll take out. Extended date. But, here, in this case, I am before, this honorable court, against an order where my lord, petition under order 21, rule 29 has been rejected. That's in order your all lots of fine starting from page 155. May I take your lordship to the operative part of the ensuing order, which is at page 160 at paragraph number 7.4. My lord has got paragraph 7.4. May I read, my lord? Yes. At this juncture, I have given due regard to the fact that the word used in order 21 rule 29 CPC is may and not shall. This very word, this very terminology suggests that the power bestowed upon the courts under order 21 rule 29 CPC is discretionary and not mandated. Various judicial pronouncements have observed from time and again that this power should be exercised by the court by exercising due care and foresight. Now, there is no denying to the fact that the two simultaneous proceedings are pending between the parties involved in the present execution case, though technically not in this code, but in a code of coordinate strength. That is, Munsif number 2, Kachar Suljar, presently Civil Judge, Judicial Division number 2, Kachar Suljar, and hence per se,
there is no bar in the application of Order 21, Rule 29 CPC to the present facts in hand. However, I have also drawn my attention to the fact that the decree holder of this case obtained the decree in this case after much labor, and the same has also attained finality in terms of the decree of the trial court being upheld by the Honorable Appellate Court, and the decree passed by the Honorable First Appellate Court also having been upheld.
So why haven't you able to get an injunction in that suit?
My lord, injunction could not, my lord, be
Then
my lord, in that suit, no, my lord, insofar as yes, injunction in the present suit that I have filed. Here, my lord, of course, injunction I have not been able to
you
get.
can only, in the case of fraud, you can establish, you can get an injunction. Why haven't you got an injunction?
My lord, that entire proceeding, my lord, even to the level of Supreme Court, it went, then it went back. Eventually, I have not been allowed injunction, it has been rejected. And the ground for rejection is also the fact that I am seeking a decree for cancellation of a decree of another proceeding.
Then also there is a Supreme Court judgment that you can get an injunction if it is a case of fraud, you are able to make out.
That is there, but unfortunately for me, my lord, up to Supreme Court level, I went, but I have not been able to get the injunction. Now, here, my lord, my only contention is the suit is at the faggot. The suit that I have filed, that is at the faggot. Now, Order 21, Rule 29 makes a provision. Now, whether this provision would have been exercised, of course, it's a discretion. My lord Shaukat, rulings of the Honorable Supreme Court, as well as our Honorable High Court, very much says that it is the discretion. But then, whether that discretion could have been, my lord, exercised by the learned court, the learned executing court. Having, my lord, observed that now there is no technical bar in entertaining this application, because otherwise this suit which is pending since 2015, that would result in, my lord, redundance, because
Why?
because, my lord, if now that your lordship, I have taken the stand, I have in fact improved. Writ has been issued for handing over possession in execution
You
of that.
are able to hold it that the suit is decreed bad, then obviously, I mean, that the is fraudulent. Then in that case, you can get for restitution.
That, my lord, of course, that option is also there. But as of now, my lord, my humble contention is, since there is a provision under Order 21 to 29, where a judgment debtor, my lord, now, in so far as the observation by the learned court, the learned executing court, to the extent that they ought not to be deprived of the fruits of a lawful decree. True, that is, my lord, absolutely fine, but when it comes to
You filed an appeal in the first suit. First suit was decreed.
first suit was decreed, I filed a appeal that was dismissed. I filed a second appeal which was also dismissed.
What is your ground of fraud?
Well, in so far as our entitlement is concerned, my predecessor had purchased a non-evictable tenancy right from my vendor, who was given that non-evictable leasehold right by one Ramdirish Chetri, who was not a party to the proceeding, the suit that has been decreed against me, and by the predecessor, one of the predecessors of the respondents in this suit, the plaintiff in the erstwhile suit. Now, taking those things into consideration, now, my lord, your lordship will kindly see the learned court below has taken note of only the fact that in one of the suits, the execution is against me and there is a lawful decree. But there is a decree prior to that in favor of my vendor. Now, there is an absolute silence in regard to that aspect, which, my lord, has not been considered. My vendor had filed.
No,
a suit.
your vendor had a title over that. Why haven't you protected it? Why didn't you place it before that suit?
In that suit, my lord, these things were produced. One thing that got missed out in that suit was the issue as regards my entitlement as a non-evictable leasehold. Now, to that extent,
Non-evictable leaseholder, how are you?
I was, my lord, a non-evictable leaseholder in the sense, my lord, my vendor was given a non-evictable leasehold right by one Ramgirish Chetri and one Surendra Kumar Dev, who happens to be one of the predecessors of the respondents herein, who are the plaintiffs in that erstwhile suit.
How?
My lord, that was way back in 1925 by process of settlement. Now, subsequently, there was clouding of rights of my vendor, for which my vendor obtained a decree in title suit 97 of 1961, against which they preferred appeal, the predecessors of the respondents herein, they preferred title appeal 36 of 1964, which was also dismissed. They preferred second appeal 115 of 1965 before this honorable court. That was also dismissed on 7/7/1970. Now, this is one aspect of the matter. Now, subsequently, my lord, there were execution of registered deeds in 1970. There were two deeds executed in favor of the predecessor of the petitioners herein.
I understand why these were not placed before the earlier suit.
My lord, these were placed. The issue that was not framed in the earlier suit, the erstwhile suit filed by the respondents herein, was whether my right as a non-evictable leaseholder because of the by virtue
So
of
the judgment may be wrong, it is not fraudulent.
that is not fraudulent, my lord, but I have paid for cancellation of that decree by saying that these
No,
deeds.
there cannot be an appeal against the decree. If it is you cannot file a suit for cancellation of a decree.
I understand, my lord, that
What you can do is, if it is a decree, is a case of a fraud, then you obviously, but this is not a case of fraud.
now, in so far as my plea in the present suit that I have filed is concerned, my lord, here only the prayer that I have made is that so far as my entitlement to the suit land is concerned, until that is established and there is an application in that,
Don't file an injunction.
my lord, injunction, my lord, once it has been, my lord, that has reached up to the highest level and has come back.
So then also the court did not consider it to be a fit case for granting of an injunction against a fraudulent, and you wonder how the executing court to do it.
My lord, here executing court may just keep the matter in abeyance. That is my humble prayer, because this suit is at the fag end. Order 21, Rule 29 makes a provision. Now, now it's a discretionary provision that I understand. But whether the discretion could have been exercised, because my suit is also 2015, my lord. It's not that it was filed just the other day. It is now almost 10 years. Now, if now my lordship, my lord has observed, my lord, that if in case I am dispossessed by exercise of, there is an option of restitution. But my lord, here my only prayer is that since there is a provision and it is as a second,
Really, because there is a provision, it does not mean, no, particularly when the Supreme Court has been hard upon the executing court, that you have to complete within 6 months. And now it has also, the Supreme Court has made the officer responsible.
that
What are
ruling,
they going to do?
that ruling has been, my lord, highlighted in the impugn order also. I
He has,
understand.
he has highlighted the ruling of Rahul Sir, but
Rahul
not the subsequent,
No, not the subsequent one, the 6
which
months.
which makes the officer responsible.
I understand, my
Okay.
lord. But my lord,
Can't help it.
my lord,
When it is the law of the land now. Can't help it.
no, otherwise, my lord, the executing court, otherwise, as per its discretion, perhaps would find it difficult. But my lord, this honorable court in exercise of supervisory jurisdiction,
If this court finds no ground,
I leave it up to your lordship, my lord. I have laid the grounds before your lordship. Now, rest I leave it up to your lordship. Only my humble contention is that my suit is also pending since 2015. They have obtained a decree in 1982. Their my lord, lawfully entitled to execute it. But there is another parallel litigation, not parallel, my lord. There was one more.
There was earlier also a revision filed by you.
Yes, that was, my lord.
That was also dismissed.
That was dismissed because of the fact that the two courts are not the same courts. That was dismissed.
That was done in 2022. 3 years have gone by till now, nothing has happened.
Look, now the writ I have, my lord, annexed that,
Lead was issued in 2022 also.
my lord, here.
Yes, kindly see that order, previous order.
My lord, writ was issued on 8/6/2022.
In spite of lead issued for almost 3 years, nothing has happened.
So, yeah, that was not because of the.
No, no, what to do, dismiss,
Stay order.
dismiss.
Give it up to him.
Chalo. But Mr. D. Chakravarti, the learned counsel appearing on behalf of the petitioner, the supervisory jurisdiction of this court have been invoked to interfere with, to challenge the order dated 7/2/2025 passed in petition number 1072/2 arising out of title execution case number 37/2017, whereby the application filed under order 21 rule 29 of the code by the petitioner, which the judgment debtor in the said proceedings was rejected. The D. Chakravarti, the learned counsel appearing on behalf of the petitioner, has submitted that the decree which was passed in title suit number 352/1981, though have attained finality in view of the same being upheld by the same being upheld by this court in second appeal number in the second appeal number in second appeal by the judgment in decree dated 11/11/2014. But there is a suit which was filed by the plaintiff, by the petitioner, which was registered and numbered as title suit number 30/2015 and presently renumbered as title suit number 692/2021, which is presently pending. The learned counsel submits that the subsequent suits which have been filed by the petitioner is seeking declaration that the judgment and decree passed in title suit number 352/1981 is null and void on the ground that it is a fraudulent decree. This court have inquired with the learned counsel appearing on behalf of the petitioner as to why the judgment and decree which have been judgment and decree passed by the learned trial court in title suit, judgment and decree in title suit number 352/1981 is being challenged on the ground that it is a fraudulent decree. The learned counsel submits that the said decree is a fraudulent decree, taking into account that the same decree was passed without taking into consideration that the petitioner herein, who was the defendant in the said suit, had the rights of a non-evictable tenant.
Purchased from the right, non-evictable tenant.
To have a right of non-evictable tenant
By virtue of what?
has a right of non-evictable tenant has been conferred the status of a non-evictable tenant, having purchased such right from another non-evictable tenant. This court therefore inquired with the learned counsel appearing on behalf of the petitioner as to whether such a plea was taken before the in title suit number 352/1981. The learned counsel, which had attained finality in view of the same having been upheld by this court in the second appeal. The learned counsel submits that such plea was not taken
It was taken.
It was taken, but the same was not duly considered. Was taking into account the above, this court, however, did not find the instance, did not find that the taking into account the above, it is the opinion of the court that if such a plea was taken before in the earlier suit, and the same have not been considered or rejected, have not been considered, comma, the same had attained finality, and the same cannot be, and finally, considering the above, this court finds is of the opinion that the learned first appeal and learned executing court had committed no error in exercise exercise of its jurisdiction while rejecting the application under Order 21 and 29 of the code, for which the instant petition stands dismissed. Be that as it may, before parting with the record, this court, however, observes that the observations and findings made herein above shall not affect the petitioner in title suit number 30 of 2015, which is presently renumbered as title suit number 692 of 2021. Thank you.
Related items in 17.
Mr. NC Das, the learned senior counsel, submits that he requests some more time in the matter. So taking into account the above, list the matter again on 16th of May, 2025. Motion. I read for motion. Delay condone.
Delay has been condoned, Lordship.
What are you challenging?
Now I'm challenging the impugn order, your Lordship, that it passed. The suit is under section 6.
Section 6.
Please pay relief.
What is your ground?
Lordship,
Decreed.
Lordship,
Good decreed.
suit decreed.
In your
So
favor.
under section 6 of the Lordship,
You are the defendant.
I am the defendant.
Then why are you challenging it?
Lordship, the trial court, your Lordship, consider the title of both the parties. So considering the title, which is not permissible as
That doesn't make it bad.
Lordship.
That doesn't make it bad. If the title applies in this court can very well make an observation that the consideration of the title shall not bar you to file a suit.
Lordship, what happened? So far, my document is concerned.
Yeah, we are into two ways. Very simple two ways. First, is there a finding by the learned trial court to the effect that he was in possession within the 6 months from the date of filing of the suit? Secondly, and on the basis thereof, he filed the suit. If that is the finding, nothing remains in the section 6.
Lordship, definitely. But so far, that part is concerned.
Well, let us see that finding. It is a sad thing that the courts have been taking up unnecessary matters.
Paragraph number
delaying it
26.
unnecessary, because the defendant stated he does not know whether so and so purchased the land. Why is it necessary? Where is that finding?
Lordship,
The
paragraph
evidence
number-
against the defendant himself and any supporting witness will have failed to discredit all convincing and failure. That the issue number is describing. Where is that finding? That he was there within 6 months.
No, Lordship, that is right. That finding is not there.
Mr. Dubey, that finding is not there.
There.
Huh?
That finding is not there.
That finding?
Not there.
That is the only finding required.
That is required, that is not given.
Number 3 and 4, whether the plaintiff has been dispossessed by force from the disputer other than in due course without the consent of the heir. Now, where is the finding that he has been dispossessed? In the evidence of AI, it is crystal clear that the shown below and in the last settlement of AI, situated in reassured that the plaintiff was in view of the damage to grab the loan by some human for recovery of possession accordingly. Man is contented, we are having heard the this to examine the entire proceedings and now thinking is the land of 24. And what is the name of the petitioner? The respondent, the plaintiff?
Plaintiff, Binaso, sorry. Devabala.
Huh?
Lordship. Soliha Warehousing Company Private Limited.
Soliha Warehousing Company Private Limited.
Private Limited.
It is further seen that the case filed by property. Finland, Vijayananda, Chaudhary, along with the name Suppression to the who is the plaintiff filed AR on 23. On the strength of the FIR, they took command. Well, how could you take over possession on 14/5? There was no declaration of possession by anybody. You say that on 19/9/2005. Huh? 19/3. It is 19/3, 2005. You were dispossessed. No, let us go by the agreement. Yes. I am not concerned with all these things. Let us come, Mr. Vivek, let us come to the point. On 19/3/2005, the defendants dispossessed. You filed an FIR on 23/2005. On the strength of the FIR, learned SDGM order passed on 12/4 initiated proceedings under section 145. It should be 145. And then the defendants prepared a revision which was dismissed by AR on 26/5/2006. Isn't it? Okay. Now, how did you enter into possession? No, understood. Where is that order for restoration? On the strength of the order dated where the plaintiff took two employees took possession of Schedule C on 14/5. But in the evening of the same day, the defendant number 4 flanked with 40 armed with AR dispossessed you. Then you filed another FI. Okay. Now, therefore, how did you enter into possession on 14/5? Was there any order for handing over possession? Did the police give you any possession to you? Because the possession has to be given by the police. If it is the order of the judge or of the SDGM, then in that way, the police has to hand over possession and the police has to give a report. Has the police, have you adduced that evidence? Nothing is there.
No.
My goodness. From 19th of March 2000, 19th of March 2025, or 2005, you were dispossessed. Okay. When did you file it? You filed it on 17th September. Okay. Now, were you on possession on 19th of March? But where is that finding? Oh, goodness, what is wrong with these judges? Working as labor in the campus substance supported the claim of the plaintiff only to the effect that on 19/3 and 14/5, working with the defendant began the accompanied by so and so 4 elements along with the trespassing to the land. Used by the defendant himself as given in support. Yes. Huh?
Find
19/3 and 14/4. These both have written all orders. 14/4 or 14/5. And when did you file that application? Huh? You sure? It has taken 10 years for a court to decide this. September 17. Hello. And this is being proved. Well, nothing is there. Dismiss. Dismiss.
Section 6 case is allowed.
Simple.
But
2
when
minutes.
they get possession. Simple. But so far in deciding the issue number 3 or not,
I'm not concerned with issue number 3 or 4. The question is simple. Whether the evidence of 2 witnesses categorically say that till 19/3/2025, 2005, these people were in possession.
is that
And the AR was filed, this plaint was filed on 17/9/2020, 2005. Within 9,
but it
within
is
6
concerned that
months.
is right.
So the question is,
How did
did
that-
you, is there any evidence you produced that they have handed over the possession to you?
Para 12 of the document?
No, 12 does not. Is there any evidence
But if we have stated,
stating would not, you cannot hand over like this?
so that is why evidence is required to be seen.
Not
or-
necessary.
We require the evidence is required to be seen, or lordship. So the
Don't
evidence.
worry, nothing is going to happen.
Lordship, because their case is concerned, on 19/3/2005, they filed an FIR alleging dispossession. So FIR has been lost. On the basis of the FIR, 144 proceeding has been initiated. 144 as in paragraph number 26 of the judgment, page 52. 144 proceeding has been initiated. That initial order has been challenged before the revisional court. Revisional court dismissed our revisional application. Does it mean that they got the does it mean that they got the possession? What is their contention? That they entered into possession of that particular property. Again. Now, that is their claim. So that is why evidence is required.
You are submitting that once they have entered into the possession. Once they have entered into possession.
Their claim is that they have entered into.
They did not.
No.
They were never in possession.
They were in possession. They are not in possession.
Then why did you file a section 6?
Initially 88, 89.
Then
That the suit was filed, anything dispossession. So that suit has been dismissed for default. So in the meantime, what happened? Restoration petition has been filed. That was dismissed. Against that FAO has been filed. So when the FAO is pending, they vacated the plot of land. In paragraph number 12 of our written statement, we have said.
okay. We don't require the records. Today I don't have the time. I can only dismissing it. Issue notice making it returnable. Issue notice making it returnable on finish it on 27th of May 2025. Mr. RDB appears on behalf of the respondent and accepts notice. Is an application filed under section 115 of the Code of Civil Procedure 1908 challenging the judgment and decree dated 13th of July 2015, passed in title suit number 313 of the 2005, whereby the learned court of the civil judge number 1, Kamrup, Petro, Kamrup and Guwahati, presently, the learned court of the civil judge number 1, the civil judge senior division number 1, Kamrup Metro and Guwahati, had decreed the suit under section 6 of the specific performance under specific relief act 1963 in favor of the respondent. The instant the registry shall call for the records and ensure that the records are available before the court on the next date so fixed hearing above. Reported by Likhidipur, the RDB appears in the extra copy of the the instant revision shall be taken up for disposal at the admission stage on the next. Don't require a stay. Nothing.
Because they are not going to file, they are not filing the execution proceeding. Last 10 years.
He wants another 2 years.
Ask motion item 49.
Yes, Mr. Pipitas.
It is allowed. This suit was initially for specific performance of contract. There was around 27 bighas of land belonging to one Sondam Mohan Sarkar. Out of this 27 bighas of land in two judgments, he initially sold 8 bighas of land to two persons, Siddiq Ali and Abdul Aziz. Thereafter, my lord, this Siddiq Ali and Abdul Aziz sold these 8 bighas of land to one Abdul Jalil. Again, my lord, this Abdul Jalil sold that land to one Otul Das. Otul Das sold the 8 bighas of land to Abdul Jalil. Abdul Jalil also purchased another 6 bighas of land from Sandra Mohan Chowdhury. So in total, Abdul Jalil had 14 bighas of land. Now from this 14 bighas of land, he sold 2 bighas to the mother of the plaintiff and 2 bighas to the defendant. So we entered into an agreement for sale.
What are you challenging? Yesterday, didn't you mention this
Yes,
matter?
yes, this one.
I remember your main problem is some order being passed by which
Yes. Impugn order is at 49. So basically, my lord, the matter was compromised,
and now then execution filed.
execution filed,
How much is the area of the land?
it is 2 bighas.
Hindu, Muslim, both.
So now the executing court is demanding that you obtain a sale permission. Now these intermediary buyers, their names are not mutable. So we could not obtain any sale permission. So the executing court is citing 21A, Assam Amendment of the Registration Act, by now saying that you first obtain NOC from the DC, then only you will execute the sale deed. Now the issue is that, my lord, if in our plain, there was a specific prayer that precept should be issued for correcting all the land records, for mutation of all the intermediary buyers. So in the compromise petition also that prayer was there. Now this compromise petition became part of the compromise decree. So the executive court would have issued precept and directed that the land records be corrected first, and then the sale permission could have been obtained. But instead of that, the executing court is straightaway demanding that we first obtain sale permission, which we are not getting. That is the issue.
If you have compromised, why you are not getting the sale permission done? Why you are filing an execution?
No, because why not in all the intermediary buyers, right from the original owners, their names were not there in the land record.
Understood.
Yes.
You are having, you have entered into a compromise?
Yes.
And thereupon why you are going for execution now?
Because why not the sale permission, NOC, we could not obtain. So basically, we wanted an order from the executing court.
That is why I am saying.
Yes.
Oh, I'll read. Let this remain. I'll read. Saying that why you are not giving us the sale permission, apply. Why you are not getting the mutation of the intermediate buyers? Get it. Cannot say this, circumvent all this thing. That is why I asked you.
Yes. All case was that there was a dispute.
Why should the court pass that order? Intermediate buyers has to be made. You have to obtain the sale permission. Obtain it. Court has rightly said. You want that without the sale permission, the executive court should do it.
But the prayer, specific prayer.
Now both of you cannot get the sale deed done. And therefore you have filed an execution. It's more of a collusive execution. Yes. What did you dismissal with cost? Collusive execution. And moving on the 227.
Compromise. So basically, we wanted for the dispute.
Absolutely, I'm not concerned. Allowing this type of petition will open floodgates. The address submits the PP does an address. The submits that will take appropriate steps which will not disconcert from which you will not practice according to the
Hello. For admission, item 18.
Yes, what is challenging?
Appointment of receiver man for collecting rent of the tenant at premises. Waiting for my lord.
Which order?
My lord, annexer, my lord, 131, impugn order, my lord, step opposite part, my lord, page 141. Okay, my lord, 140, last paragraph. It is in the
Eight.
my lord,
Un.
140.
People shall submit a report to the court within 10 days of taking possession of the suit in the building and thereafter submit monthly
140, my lord, 140, case number. Property part of the order, my lord.
Seen that
It is
you
in
have
the
claimed ownership over the share of the other two legal heirs of Sri. Order dated 18/1/2025.
My lord.
What do you want? We admit the appeal.
Yes.
And what do you want?
Admit the appeal. Admit the appeal, my lord.
Only.
My
If there is an appeal filed under order 43 with 1S, where with section 104 of the Code of Civil Procedure challenging the order within 8. In petition number 2576 of 2022. 763 of the 2020, by the learned court of the Secretary, whereby the application filed by the plaintiff under order 14 for appointment of a receiver was allowed.
Yes.
The appeal is admitted, call for the report, steps be taken from the respective by way of registered as well as usual. To circumstance, the learned counsel appearing on behalf of the appellant submits that there is some urgency in the matter. Taking into account the above, the list may appeal for appeal again. Appeal on 28th of May 2025. In the meantime, liberty is given to the appellant to take steps upon the respondent by way of the state to the registry of the spot and file an affidavit of service on the what is this I business?
I am stay keeping against the thing that
This is an application, issue notice kori. List the matter and so steps be taken. Stay of that order dated. Finance.
19.
Enhancement,
No, my claim petition was rejected
why?
on the ground that the cause of the death was not in accidental death.
What?
Under the paragraph 5, page 12. 5 and 4 and 5, your lordship. Precisely. There was I in place, but there is no any whisper of the evidence sitting that I in place.
What is the vehicle number?
And the vehicle number that is.
Huh?
Shiva. AS 23BC 4584. That is your.
Then
Vehicle number that was
how
not.
do you know the vehicle number?
Lordship, in the evidence and the lordship charge sheet. Charge sheet was filed against the driver of the vehicle. That is the vehicle number, lordship, AS 23BC 4585. Tata SC. My lord, evidence of the eyewitness lordship has totally discarded. There is no whisper in the charge sheet. And FIR was lodged by father-in-law of the claimant number 1.
So you are the claimant
And the husband and the 2 minors.
and you are changing your wife.
That is the allegation in the FIR. FIR lodged by my father-in-law.
And while pelting stones at your wife,
That is allegation in there.
she met with an accident.
That is,
And now you are claiming compensation.
my lord, husband and two minor sons.
Huh?
Two minor husband and.
Where about the minor? You. Who are you?
My lord, number one, claim,
So in order to give the color of accident
that is,
and get away under 304,
that, my
I
lord,
want to make it under what
My
is
lord-
this sections 279 and 304A.
that was the allegation there.
Now, after I admit the appeal, what are you going to do? You say that as the appeal has been admitted by the High Court, so the trial of that offence should be stayed.
No, I am not,
304,
trial of the offence process, I am not on.
that also charges has been given.
No, so that
The
is,
304.
that is Sashik, yes. Sashik,
One, that FIR has also been charged with
yes.
how the wife died.
But,
And there is another charge sheet. There are two charge sheets. One is under 279 and 304. A.
in the same, Sashik Rashid, both the claimant number one and the driver of that vehicle, who is Sashik. And that FIR Rashid, was by father-in-law, but he tried to implicate the present petitioner because there was a domestic violence. Allegation of domestic violence between the deceased and the claimant number one.
Yes, I think we should appoint somebody else for minors. They should get the compensation,
Yes.
not you. That should go to the jail.
And that will time will take its action also.
That is why
And at least was two sons, minor sons.
they will get it definitely.
Yes,
You will come within the ambit of you are the murderer of your wife. So 22 will come in, na?
and that will-
Hindu succession, that succession act is there, na? Yes, Hindu succession act, 22. What else? Murderer does not get any property. He will come within that act.
that conviction part is not yet done.
Not necessary. You should not get any single.
It's subsidy.
No, pelting stones at your wife and she met with an ex. Yes. Now, there is an appeal filed under section 173 of the Motor Vehicles Act 1988 challenging the order dated judgment in order dated 7/2025 passed in MSC case number 28 of the 2024, whereby the claim proceedings was dismissed. Mr. M. and the learned counsel appearing on behalf of the appellant has submitted that the findings were arrived at by the learned tribunal was not at all justified on the basis of the evidence on report. Further to that, the learned counsel submitted that the learned tribunal did not take into account that the claimant number 2 and 3 were the minor sons of the deceased, who also had a right to the compensation if the mother expired on account of the accident. He submitted that this very aspect of the matter was not at all taken into consideration by the learned tribunal. Taking into account the said grounds of objection, the instant appeal is admitted. Was the call for the record, steps be taken by way of registered. We are not entitled to one.
20.
Yes, what is the ground of objection?
For enhancement of the award. For enhancement of the award.
Why?
Because my lord, the learned tribunal has not taken into the future prospect of 40% are not the national income.
Huh?
The notional income has to be taken as 18,000, he has taken only 9,000.
By notional income,
Because he was a driver minus skill level. Skilled driver minor. There's a category, the skilled, semi-skilled and all. That was my. I have stated in paragraph D as well as paragraph E.
annual income is 9,050.
9,000 by
No specific document or anything is submitted to support the deceased earned 50,000 per month. In absence of a proper document, notional document is, notional income is taken at 9,000.
the national, but our circular says it's 18,000 by our high court also.
What?
The national income will be 18,000.
Why?
Because this circular by the government,
No, why?
this government has decided for the skilled worker.
Skill. Now,
Yes.
did you prove that you were skilled?
Yes.
How?
Because the driver is come within the skilled man. The driver
Hmm.
is come within the skilled man, and he's also supplying the contract for supplying rice to the government also. He's a contract driver man. That is skilled. That is the notification given.
There's not a single finding that he could be. The driving the vehicle here by the driver.
Yeah.
So it is clear that the accident was due
the-
to negligence of
evidence is
driving
there.
of negligence of the vehicle by the driver. The said vehicle was insured with claims. Since the vehicle number was insured with opposite party. Who is the driver?
Well, this is rural. He was
Where
driving.
is the finding anywhere that he was a driver?
My lord, he is the driver. My lord, he was driving a Pulsar.
Huh?
He's by profession, he is a driver, my contract driver.
Going to Korea by a vehicle number, even motorcycle Pulsar.
Yes, he was driving the Pulsar.
Then how do you know that he's a driver?
We have produced the documents, my lord. He's a professional driver license and.
Huh?
We have produced before the court, my lord, the license. He has a driving license.
Exhibit 1 is from here, exhibit 2, what are the exhibits? Let us see. Where? You don't have that.
My lord, the court has come to the.
Exhibit 1 is, no, Form 54. Exhibit 2 is FIR, exhibit 3 is charged with, 4 is sketch map, bail bond, MBI report,
Yes,
Caesar memo, Jima number, postmortem, medical is a cash memo. Where is it? Driver.
my lord. Well, that is why, my lord, we have asked for
Okay.
the national income, my lord.
Today I have not disposed of any MSC matter, so this is the first dismissal.
My lord, that is why I said, my lord, national income.
National income, nothing. You have not produced anything. The first dismissal today.
My
Hello.
lord, that is their driving license, my lord.
We don't find any good ground.
My lord, page
Dismiss.
6, your lord, page 6.
What?
Page 6 of my petition, my lord.
Page 6.
Yes, my submitted photocopy.
No, no,
PAN
no,
card,
photocopy now. Where is the evidence? You have to give evidence.
evidence has to be called for, my lord.
No, kindly see what are your exhibited documents at page 31. Don't make this submission. And future prospects has been taken 20,000.
Yes, that is the Pranay City's case is 40%, my lord. That is going to come around 40%, my lord.
Why?
That is given by the Supreme Court, my lord.
40%.
30% in the future prospect, my lord. I have stated in paragraph B, your lordship will see, paragraph D. I have cited also that.
Out of the state.
For that, in support of the Supreme Court, Gurujit Kaur and others in the Injunction company decided on 22 and
No.
our own high court decisions on well.
But anyways, love and affection, you got 1,20,000. You shouldn't have got that. We reduce that. If we reduce that, then also it becomes the same. Now, if you go by pronosity, you are not entitled to 1,20,000. So that we remove it. Funeral expenses, we put it at 15,000. Loss of estate, 15,000. Loss of future prospect, it will be okay. Medical expenditure, here, no case.
My lord, so lordship comes to my calculation, that is what I given in the petition, my lord.
No case, no case, Mr.
Yes.
Let me dismiss your case.
My lord, your lordship will come to the page 13.
No, 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 no,
13
no.
of my
Today, one day, one case has
My
to
lord,
be, can
the
we
13
see, has to
kindly your lordship come to page 13.
Third, Mr. K. Bachati, the learned counsel appearing on behalf of the appellant. I have a case.
My lord, your lordship will come to the page 13, my lord.
No, no,
That page 13, I have given the multiplication, my lord.
what 13?
Page 13 of my petition, my lord.
Yes. What is that?
Page 13.
Actual income 50,000, you
Yes,
have
that-
nothing.
That I have stated.
There's 1/3, 33, nothing. Multiply
Multiply
18,
18 is okay, my lord.
18
Future
is
prospect.
done properly. Future prospect 50%, where is the future prospect of 50%? Can't be 50%.
Then my lord, loss of
Loss of consortium,
debt,
how many?
funeral expenses, future prospect.
When did the accident happen?
My lord,
Accident happened when?
700 on on 13/5, my lord, 13/5/23.
23. There is an appeal filed under section 173 of the Code of the Motor Vehicles Act 1988, challenging the judgment and decree. Judgment and award dated 21/2025, passed in MSC case number 62/2023 bracket B, whereby the compensation awarded to the claimants, public the appellants, was rupees 12,42,994. The learned counsel appearing on behalf of the appellant submitted that the future prospects which was awarded is on the lower side, taking into account the judgment of the Constitution Bench of the Supreme Court in the case of National Insurance Company Limited versus City, reported in so and so. He further submitted that on account of loss of consortium, no amount have been awarded. He therefore submitted that this is the case where the petitioner appellants are entitled to a higher compensation. Taking into account the said grounds of objection, the instant appeal is admitted, call for the record steps to be taken by way of register. So you survived.
You are.
Yes, what is this?
For enhancement.
Why?
Whether I have executed the disability certificate, which says that it is 90% permanent disability. With respect to my left hand, which was amputated at the root, madam. So,
And how much did the court decide?
no, that was not granted.
Huh?
No, that was not taken into consideration, disability certificate.
Why?
Because,
You got it from somewhere, you must have got that disability certificate
from
from
the
a
same
skin
side.
doctor.
no, this is from
Hmm.
Joint Director Health Service, Jorhat. The same place where I reside and I got injured. The private,
Where is the pain suffering, where is the finding as regards the disability?
says that the issuing authority was not.
Huh?
Yes.
Where?
Paragraph 36.
In file under section 188 of the Motor Vehicles Act 1988, challenging the judgment in the award dated 15/2025, passed in MSC case number 2208 of 2019 by the member agreement between Company Secretary and Guwahati, whereby an amount of rupees 6,34,500 have been recorded in favor of the appellant, along with interest at the rate of 6% have been awarded in favor of the appellant. Counsel appearing on behalf of the appellant submits that the compensation so awarded is not reasonable, taking into account that the visibility that the factor that the petition appellant is suffering from 90% divisibility was not taken into consideration. So we therefore refer to paragraph number 56 of the impugn judgment and award and submitted that in the proceedings before the tribunal, the strict laws of evidence is not applicable, taking into account the above submissions. The instant appeal is taking into account the safe ground of objection, the appeal is admitted, call for the court steps be taken by way of the district.
Carrying under order 41 I think.
Yes, what is this? Ah, this matter, where you are not interested in doing it. But no, there's a judicial order. How many times you have taken adjournment from me? Let me count out. Every time the matter comes up, you have taken that. 17/5/2024, 10/4/2024, 26/4/2024. Time taken payment. When did you file the appeal? 2021 to 2023. And you have been taking adjournments. What is that? Suit has been dismissed. Decreed. Have you put it to execution? Should I say that they can go ahead with the execution? Oh, I have already. Okay. Please observe that filing of the second appeal before they would not amount to stay. The learned tribunal would be able to proceed with the execution proceeding in accordance with. So we have it after another 6 months. We will again ask for time only. You want to do it? Fantastic. Do it. Your suit has been dismissed concurrent. And his counterclaim has been decreed concurrent. Now you have filed one second appeal.
Judgment, I filed the appeal, although, two appeals are not, but, one appeal was filed.
So you have paid the court fee for both. Huh? How much is your counterclaim? Value that? What is the court fee it will be? And here, what is the suit value that?
5,000.
So you have paid the court fee for both.
We have paid 36,000, 3,600. We have paid 3,600.
That is not proper. You have to pay more. Pay another 3,600. It's okay. Here they were filing out here, na? So let the government also get some more money from her. Then we dismiss it after getting that money. It is seen that against the decree passed, against the joint decree passed in the suit as well as in the counterclaim, a single second appeal has been filed. This court, however, it is, however, relevant to take note of that the court fee of only one appeal have been paid. The registry shall make necessary. Shall duly take a note of that. And inform the counsel appearing on behalf of the appellant as to how much additional court fee is required to be paid. Within 7 days from such information, the appellant shall pay the said court fee, and thereupon the appeal be listed before this court at the stage of order 41 million. How? Why do you need it? I've allowed you to go for education. I'm only asking him to get more money from her.
23.
Ah,
Second appeal,
which one?
regarding my specific performance.
Oh,
If
yes.
the court decreed the suit, but they directed that the money should be refunded. What she wanted to examine, that even if a suit is filed within a period of limitation, whether there is a due diligence on the part of the intended purchaser or not. Regarding that matter, I have found the judgment, 2024 judgment, the judgment was relied. But 2024 judgment, para number 17. It relied, para number 16, man. It relied on 2011 judgment.
Huh? 2024.
Yes, para number 16.
Yes, I told you this.
Yes, yes. Para number 16.
In a civil dispute, the conduct of the hearing is material. The appellants have not approached the court with clean hands. From the conduct of the parties, it is apparent that it was employed to salvage the property from sale in the execution. How is that really?
16, man.
Huh?
Para number 16.
1/6.
1/6. Last.
This court held that
In
sentence
Sar-
for Iran need not be decreed merely because it is filed within the period of by ignoring the time limits to be made. This court will also frown upon a case that entered into an agreement with only one of the proponents and thereafter sought extension for execution. It does not describe in the suit well. You are aware of the sale deed dated in executed from Cleveland instant and within the court. As from the strength of the observations made by Hindu.
Seven judgment. This is relied. Para number 28. Para number 28. 28. Point number 3. That is the relevant point.
Now your possession has been handed over.
Yes, the majority amount of the consideration was paid. And since 2010, madam, we are in possession. Out of 75,000, we already paid 70,000, 3,000 in. So, madam, will be madam very technical approach, madam, if you say that, madam.
Technical means, why did you wait for 2 years?
The, it's
Because we are concerned with the different situation.
Agreement was for 11 months. But the final came before the court in the year 2012.
In the field file. Under section 100. Out Mr. Ezra, the legal counsel appearing on behalf of the appellant was in appeal file under section 100. Challenging the judgment in decree dated 29/7/2024 passed in title appeal number 30 of 2022. Whereby the appeal filed by the appellant was dismissed. Thereby affirming the judgment and decree dated 28/2022 passed with the learned municip number 1 Borpeta in connection with title suit number 355 of 2012. The instant appeal is admitted on the following substantial question of law. Whether the learned courts below were justified in rejecting the claim of specific performance that too when it was found that the suit found that the agreement for sale was a valid agreement and the appellant, the plaintiff, have paid the major part of the consideration. On for the record, steps be taken by the
Hello.
For order, item 24.
Page 24.
24 for orders.
None appears on behalf of the party again. Who is the board?
Case, my lord. Regarding service, my lord, kindly see the Okalotama filing IA 1566 of 2022.
What are you paying for? Who's number 2? How many respondents are? Huh? Other respondents. So service is complete.
No, only, she is appearing only,
How many respondents are there?
not up to 7. 6 initially, thereafter substituted. So there are more respondents, all at the legal years of respective 1, 2, 3, 4, and 5. And kindly see the Okalotama filing 1566 of 2022.
What is that?
Here appeared by 1, 2A, 2B, 3A, 3B, 4A, 4B, 4C. Kindly see that there are a couple. 1566 of 2020. I have flag marked that Okalotama.
So what, respond number 3, 4, 5?
Kindly see that Okalotama.
Who is filed?
Emil Mondo and I 156. I flag marked that Okalotama.
1566 of 2020.
Who is the plaintiff?
I'm
You're a plaintiff. And who are the defendants?
defendants, they are jointly filed written statement, brothers and sisters. Jointly. Expired.
প্রায় এখনো তুমি সব
1566. Respondent number 5 did not contest.
these have been received, acknowledgement have been received. The service is complete. This court have duly taken note of the ID cards, returned ID cards in respect to the respondent, newly included respondents. Taking into account the above, this court deems that the service upon all the respondents are duly complete. So the NCR having been received, list the matter for hearing in the usual course, liberty given to both the parties to file application for a hearing. Mr. Doctor, in the meantime, you ask your client to get everything was a joint written statement appear. Not cooperating, it will go against them, nothing doing. What? Who did it?
Filing I
Understood that Manu Mondal has returned the file. That is also absolute. 26. 26.
The order dated passed by the Superior Court on 9.
Have you filed the service?
And we have, today we have filed affidavit regarding the completion of service.
The affidavit come on record.
No. Today we have morning we have filed.
Why didn't you call for it? You are paying for whom? What about 4A to 4D? Have they accepted it?
Yes, accepted. And in this regard, I filed the affidavit today.
You have a copy of the affidavit? Who is Narayan Bro?
The uncle of the defendant number 1
Huh?
is one a family member and uncle of defendant number 4A to B, and brother of the late Suryakanta Boro, who on for whose behalf his legal representative has been substituted. Brother of late Suryakanta Boro, who for whom this legal hair has been substituted for this honorable court. Personally took the notices of the all the respondent.
It seems that pursuant to the order passed by this court on 9/4/2025, steps have been taken upon the respondent numbers 4A to 4D by way of the stick. And 58, 34. Ah. He has taken service by way of justice service. Okay. Who are you? You are the defendants or plaintiff? All of you have filed joint written statement? So all of you are brothers, sisters? One to four all? So get hold of that and appear.
Office not dated 22/4/2025.
File their certificate of service and from the above and for a perusal of the above. Opinion of this court that the service upon the respondent number 4A to 2D is deemed to be served. So accordingly, the service being complete is covered. What is this? Division?
Against division.
Against what?
Against the dismissal of the application filed under order 22 rule 4 for substitution of the legal hire of the defendant number 1.
This is division for admission on 2nd of June 2025. An attempt shall be made to dispose of the matter.
27.
Not fourth. Fourth of
27.
what objection? What objection? Huh? What are you filing? 255 or 2016? 2016 is what? Why have you filed this petition?
The dismissal of the complaint.
Huh?
This third round of litigation.
Understood. Don't make it fourth. Now tell me, why have you filed this 27? Item number 27.
I'm against the impin order passed by the London Civil Judge Madam 29/3/2016 Madam, whereby the complaint filed by me Madam in the specific performance of the contract under 6 of the specific that has been Madam dismissed Madam.
Why?
Dismissed Madam totally discarding the plaintiff. They are the plaintiff Madam. I am the defendant petitioner before you.
Why it has been dismissed?
Dismissed on the ground that there is a perversity evidence of PW1 Madam totally discarded. They plaintiff PW1 Madam said that yes,
Is it a case of under section 6?
yes Madam. Yes Madam.
Under section 6 of the specific relief act?
Madam.
No, specific performance. What is your suit for?
Specific for disposition Madam.
You filed a counterclaim.
Filed the counterclaim Madam.
What is the scope of a counterclaim in a proceedings like this? Under section 6, the scope of counterclaim is there.
I had filed Madam.
You filed very well, rightly dismissed. And what objection you want to file? Make it there. So this matter again on 4th of June 2025 for final disposal at the admission stage.
28.
Yes, what is this? Who is appearing? M. Hawk, the Learning Council is doing so. Fill out the page 3 of the year's not been shown. I find the submission. None appears on behalf of the petitioner on call when the matter is taken up. Mr. So-and-so appears on behalf of the respondents. Mr. Petition. What is the challenge out here? This court have duly perused the order dated, including order dated 3/2/2028 to 2018, as said in the instant proceedings. And do not find any good ground to interfere with the said order. It is further seen that in the said instant proceedings, the suit, there is no stay to the further proceedings of the suit. So considering the above, nothing further remains in the instant proceedings for which the instant proceeding petition stands dismissed. Denied. None appears on behalf of the petitioner on call. Mr. So-and-so, the learned counsel. Who are you? The G, you hear the learned counsel appearing on behalf of the respondent number 3 submits that in the meantime, the suit filed by the plaintiff have been dismissed. So thereupon, an appeal has also been filed which have been dismissed. By the judgment and decree dated in title appeal number by the court of taking into account the above, the instant proceedings have become infructuous for which the instant proceedings stand. Here's 29.
29. There is an office note. Please.
CRPIO you're finding?
Section of party amendment.
Service why you are not being able to make protect?
But it says that none of the notice has expired by the time it reaches the office. Reach the office of the municipal minor to expired.
There's no stay.
Yes.
So what happened?
It's minor at the stage of appearance because of pecuniary jurisdiction minor. Earlier it was before the senior division, now it is before the junior division.
And this order was passed in 5 years back. Nothing has happened in the suit. Can't be. It's impossible. How is it possible that for the last 5 years, the suit, nothing has happened in this very court? Is it because of that? Because today in the morning, I issued notice in one of the motions. The civil judge come to coming down. 5 years, nothing has happened in the suit.
That's my.
Learned counsel appearing on behalf of the petitioner shall apprise this court on 9th of May as to what is the present status of title suit number 11 of 2014, which is the subject matter of the instant proceedings. Yes, what is this?
Yes, my lord, there is a gate.
What you are challenging?
Expert degree was, my lord, challenged, my lord, in proceeding and then,
Tenant. Landlord tenant.
oh, my lord, landman.
Huh?
Land,
What?
right title and interest.
Why you are filing revision?
Division, my lord, suit was decreed ex parte, my lord. Then we filed a petition, my lord, for vacating. That was also dismissed. Then we filed an appeal, my lord. Appeal was also dismissed.
So what are you are filing therefore 115? It was decreed.
Got
Has it been put to execution?
But the execution notice was, my lord, when we received, my lord, then we file application for
But
vacating.
there is no stay here. Then it is seen that notice have been issued
Present state.
on 8/10/2021. But there is nothing, but no steps have been taken for service of notice upon the respondent till 25/3/2025. Considering the above, it appears that the petitioner is not interested in the instant proceedings for which the instant
One day
proceeding
time
stands
will be
dismissed for non-prosecution.
One day,
5,000?
one day time will be taken. I'll take step.
Cost of 50,000. No steps have been taken till 25/3/2025. Taking into account, Mr. R. Ali submits that a final opportunity may be granted to the petitioner to take fresh steps. Taking into account the manner in which the petitioner have been dealing with the matter, this court for the ends of justice grants a final opportunity to take steps within 7 days from today, subject to a deposit of a cost of ₹10,000 before the registry of the school. The registry shall, on deposit of the said amount, shall place the shall disburse the said amount to the legal service authority.
1,000. I keep it brother and sister.
15,000, huh? 15,000. Okay. I have a meeting. Any urgency? Anybody? We make it 15,000. Yes, what is it?
Number 39, that is a hearing order till the next day.
So any interim order, just tell him, you will extend it. And anybody wants a date, you get it.
I think now notice was listed for hearing, my lord. The last occasion the petition appellant is not appearing with the court. And now nobody has filed any, I had ordered date 8/4/2025. Registry was directed to issue notice to the appellant.
Madam, I can't do now anything to that effect because of the fact that you wanted early date, I can put for the.
Obviously,